Okay, we are live on YouTube and Miss Kippenbrock will be putting the link in the appropriate location very soon. So you can take it from there. Hearing Examiner Schaefer.
Thank you. Thank you, Hearing Examiner Gecko. I'll also just reiterate for all parties, we are on YouTube live streaming all day. So just keep that in mind as you navigate your cameras and your audio throughout the day here. Once again, good morning, everybody. It's 9:10 a.m. in Santa Fe, New Mexico. I'm Patrick Schaefer, hearing examiner for the New Mexico Public Regulation Commission, joined by my colleague, hearing examiner Kevin Gecko. We're here for day two of our hearing on case number 2500079 UT, which is in the matter of Southwestern Public Service Company's application for revision of its retail rates under advice notice 341, specifically the evidentiary hearing for the certification of a comprehensive stipulation. So I think we're about to back into our party testimony, continuing with SPS, specifically Ms. Johnson from carrying over from yesterday afternoon. There is just one or two things I wanted to address before we get started on the record. And one of those is a bench request that arose after a colloquy between hearing examiner Gecko and SPS witness Zoe Lees. And that request was for any agreements or stipulations or orders that establish any transfer costs on which SPS has the right to earn a return. So I just thought we'd check with SPS counsel briefly to get an update on when that bench request may be filed so that the parties would have adequate opportunity to review that evidence.
Good morning, Mr. Examiner. Dana Hardy for SPS, and we are putting together that bench response, and I believe we should have it in by noon, I believe.
Okay, thank you. And it's really not a pressure, just again for situational awareness and organizational purposes. The other thing I just wanted to address with the parties before we get started was the question of asking witnesses for legal opinions or legal conclusions. And this has come up in previous hearings. It has come up yesterday as well. And hearing examiner Gecko and I try to adhere to New Mexico rules of evidence as closely as we can. Obviously, as we all know, there's some discretion and flexibility with commission rules, but we really try to stick to that foundational understanding so that all parties have a solid framework from which to proceed with respect to evidentiary matters. Now, there are generally we're dealing with expert witnesses here in these proceedings, and expert witnesses do have some ability to comment or provide some opinion on legal issues, mostly on an exceptional basis with respect to the concept of an ultimate conclusion. So that it can be acceptable, but what I think hearing examiner Gecko and I want to avoid is witnesses providing abstract or general understandings of what the law is. That is the purview of the trial court or the commission or whatever the tribunal is that is hearing the matter. So please let's refrain from asking our witnesses what the law says or what this rule says or what the powers of the commission are. I think that there is, again, some leeway with respect to this concept of ultimate conclusion that many of you may be familiar with from your time in civil litigation. But in any case, that is often related to a factual presentation or a factual issue that involves a legal question. So with that being said, I think we're ready to get started. Hearing examiner Gecko, do you have any final thoughts before we resume our testimony from Ms. Johnson?
My only thought would be to be clear on whether the chair would like to answer or ask any questions first. I always want to make that deference.
Good morning, all. Pat O'Connell. I don't have any questions prepared for the witnesses. I expect to be there today, and I'm paying attention to this hearing. If I'm not here, I'm watching on YouTube, but just appreciate hearing examiners giving me that opportunity. And these hearings very much improve the outcome of our work. So appreciate everything everybody's putting into it.
Thank you. Thank you, Chairman O'Connell. Okay, Ms. Hardy, are you ready to recall the witness?
Your Honor, William
Oh,
Coe.
Mr. Coe, thank you. Let's just have it. Good morning. Good to see you.
Good morning, Your Honor. Yes, Your Honor, SPS recalls Ms. Allison Johnson to the stand.
Good morning, Ms. Johnson.
Good morning, hearing examiner.
Yesterday in our discussion, you referenced the removal of the solar PTC DCAs when we were looking at table AMJ Stip R1, which is in your rebuttal testimony in support of the stipulation. Do you recall that?
I do.
In your testimony in support of the stipulation on page 15, line 5, you state that, I'll give you a minute to go there.
Thank you.
Can everybody still hear me?
Yes.
Are you there, Ms. Johnson?
Yes.
And so you state there that the removal of solar PTC DTA from rate base represents a compromise among the signatories and results in a decrease to SPS's revenue requirement and the rates charged to customers. That sentence reflects what we're seeing in that table. And then you state SPS maintains an avenue for recovery of these costs through FPP, through the FPP CAC. Is that avenue an avenue whereby SPS has the ability to request that, or is that an avenue that is in effect? And so that solar PTC DTA amount that we see is just going to be recovered through another avenue. Could you inform me on that, please?
Sure. So the other avenue we're referring to is the FPPCAC. That's the fuel mechanism. So within the stipulation, it was agreed to, I believe, in the 24 fuel continuation filing that we would recover these PTCs through the fuel mechanism, but instead we would address any return on the DTA within the SPS's next base rate case, so within this proceeding. So it was agreed to within this proceeding and in the stipulation that we would earn a return on that DTA, and that would be recovered also through the fuel mechanism.
So is the DTA in and of itself, not the piece, not the return on the DTA piece, being recovered through the fuel clause as well?
Yes, that's correct.
So the amount that we see in the table there is simply not being recovered through base rates, but instead being recovered through the FPPCAC, both the base amount of the DTA and the return on the DTA. Correct?
That's correct. That's correct.
Okay. All right, thank you. Then I want to turn a little bit to transfer costs. This was a topic that I discussed with Ms. Lees. And what I referenced there was direct testimony from Ms. Lees, and this is common knowledge, I think, to parties in the case, that there can be transfer costs incurred to monetize. In this case, I'm referencing the Hale and Sagamore wind project PTCs, and they're capped at 10% of each PTC's nominal value. I believe that's been agreed to in the stipulation as well. Is that correct?
Yes, that's correct.
And then that's the bench request, I believe, my first question, which was, are there any transfer costs you incur on which you earn a return? So I'll skip that. So my question goes to, why 10%? And the context for this was that the little bit of research that I was able to do showed me that there's a general understanding, and I know not to take it as absolute when I find something through Google searches and such, but that those transfer costs average between 4 and 10%. And so if 10% is the high end of that generally understood number, then is there I'm curious about whether there's any incentive to hold those costs down, and also whether there's a mechanism, is there an ability of SPS to effectuate, what those transfer costs would be? Like, is that a negotiated term in the market, speaking generally? So that's a two-part question. Why don't we start with the second part being, does SPS have any ability when it enters the transfer market to influence the percent of transfer costs?
That would be an appropriate question for Miss Naomi Koch. I don't have direct experience with the transferability market.
Save the first part of the question for Ms. Koch then as well.
Yes, thank you.
So this goes back to yesterday as well, and one of your answers indicated that the decision of whether to cash out a production tax credit is a financial decision. And that was within the context of, discussing that it's been agreed to have a return of long-term debt on a booked PTC. And could you explain to me what weight is given to the financial effect on ratepayers when you make that decision?
I would say that in terms of whether or not to monetize a PTC, which is what I'm understanding your question to be, and how we weight, the benefit to the customers. The customers have already received the full value or the full benefit of the PTC, which is why I refer to it more as an economic decision on behalf of SPS, because the customers have already received the benefit. It is now SPS's determination whether we can utilize that tax credit to offset a tax liability, or if that is not an option, if there's an ability to monetize the credit through a transfer.
Okay, thank you. Let me just double check a second document because of the transfer of questions. I just want to make sure. I think that's all my questions, but if you can bear with me just 1 minute.
No worries.
Yeah, that's the extent of my questions at this time. Thank you for the back and forth. I appreciate it.
Thank you.
Thank you. Thank you, Ms. Johnson. Mr. Coe, do you have any follow-up after hearing Examiner Getko's questions?
No, sir.
Thank you. Okay, I don't think any other party had time reserved for the cross-examination of this witness, so unless there's any objection, Ms. Johnson, you may be excused.
Thank you.
Thank you again for everything. Okay, so SPS, I'm not sure if Ms. Hardy will be calling the next witness or Mr. Coe, but we are ready for your next witness.
Thank you, Mr. Examiner. And our next witness is Mr. Todd Wayner. Might just take a minute for him to join the Zoom.
Yes, no problem.
And I apologize I had not yet returned Mr. Hearing Examiner Schaefer to being a co-host, so the wait was because of Mr. Wayner being in the waiting room. So all of that has been fixed at this point.
Thank you. Thank you. Good morning, Mr. Wayner.
Morning.
Is that the correct pronunciation, Wayner?
Yeah, Wayner. It sounds like a trainer.
Sure.
Thank you.
Perfect. Thank you again for being with us. We're going to get you sworn in by our court reporter here in just a few seconds. And once he's ready, he will proceed to swear you in.
Perfect. Thank you.
Thank you.
Mr. Winter, would you please raise your right hand? You solemnly swear the testimony you're about to give, no matter not pending, should be the truth, the whole truth, and nothing but the truth. So
I do. Thank you.
go ahead.
Well,
Thank
Thank you, Mr.
Thank
Lee.
you.
Go ahead, Ms. Hardy.
Thank you. Mr. Wayner, can you please state your full name for the record?
Todd Allen Wayner,
By whom are you employed and in what capacity?
Excel Energy and the associated operating companies. I'm the vice president and treasurer.
And Mr. Wayner, did you prepare exhibits 5, 6, and 7, which are your direct testimony, supplemental testimony, and testimony in support of the stipulation?
I did.
Thank you. And since those documents have already been admitted into evidence, I have no further questions for Mr. Wayner. He's available for examination from the hearing examiners.
Thank you.
Thank you, Ms. Hardy. Did you want to ask on direct the question that the chairman had?
I don't think that's a question
Oh,
for Mr.
sorry.
Wayner. That's okay.
That's right.
Thank you.
That's right. No, thank you. Good catch.
Thank you.
Okay. Yes. So we had, I believe, the only witness or the only party that reserved time to cross-examine Mr. Wayner was staff with 10 minutes. Is that correct?
That's my understanding, Mr. Examiner.
Yes. Ms. Amer?
I believe we have no questions for Mr. Wayner.
And we'd like to reserve our time if we can and shift it.
Okay. So currently there was 23 minutes left in the time reserved, Mr. Elliott, from your cross-exam of Ms. Lee's, and then some was used by Ms. Amer with Ms. Johnson. So I'm going to add 10 minutes to that for a total now of 33 minutes.
Thank you.
Sure. Okay, so no cross-exam, no redirect. Chairman O'Connell or Hearing Examiner Gecko, if you have any questions for this witness, please proceed.
And no questions. Thank you.
I have a few questions. Thank you. Good morning, Mr. Weiner.
Good morning, Mr. Hearing Examiner.
So this is in reference to your direct testimony on page 14, on line 8. You explain that, quote, for the issuer, equity financing reduces financial risk as it secures capital with no additional obligations. And that's in reference relative to financing through debt, correct?
I actually don't see that at line 8, so I'm not sure if that's the correct reference that you pointed me to on page 14 of my direct testimony.
Yeah, let me see if I made a mistake. 14, direct testimony of Todd A. Weiner. The top of the page starts line 1 with increased risk for the issuer. Are we seeing the same thing?
I see the same, and you said
So-
line 8, sir?
Line 8 at the right-hand side, it starts with for the issuer.
Thank you. No, actually, this is definitely referring to equity capital, quite frankly. So the additional obligations or the lack of additional obligations that I'm referring to is in effect the coupon payment that is associated with risk. You know, if you have a debt obligation, you have to make coupon payments, and so therefore there is risk that is drawn from that, and it's reflected in agency rating agency.
I'm sorry, Mr. Weiner. I'm sorry, Mr. Weiner. I'm going to get lost in that, and it doesn't go to what my question is. I appreciate that.
Okay.
I'm going to refer you to line 3 above in that same paragraph. You say that equity capital is subordinate to debt in the capital structure, meaning that its claims are paid only after all senior claims are settled. Do you see that?
I do.
That's what gave me the context for, without reading the whole paragraph, coming to the point of, for the issuer, equity financing reduces financial risk as it secures capital with no additional obligations. With that context, am I correctly understanding, and we can even put it in general terms, that a higher amount of equity in a debt equity ratio, and I'll just say for everybody here that I always have trouble with saying debt equity ratio, because when everybody puts it on paper, they actually put the equity number before the debt number. And so I don't understand why people don't say equity debt. But if you have increased equity relative to debt, a ratio with higher equity compared to another ratio with another level of equity, that higher equity ratio would reduce the financial risk of the company. Is that correct?
No, that is not the way that rating agencies look at this.
Okay, can you explain how they look at it then, please?
Yeah, it goes again. So if you take a step back and think about how rating agencies look at this, they look at metrics of cash flow to debt, and whether it's CFO pre-working capital at Moody's or if it's FFO to debt ratio.
I'm sorry,
at
sir.
S&P.
Excuse me, sir. Can you start that sentence again? And you're speaking just a little too fast for the acronyms.
Apologies. Let me try again. So I mentioned CFO, pre-working cap, which is cash flow from operations, pre-working capital. That ratio over debt is the one that Moody's cares about, and FFO, or free cash flow from operations over debt, is the ratio that S&P cares about. And so in both, they're concerned with how onerous are the debt obligations that a company has, and how encumbered by those debt obligations is a company in being able to continue operations. The more debt outstanding, the larger those coupons. Both of those lower the free cash flow that a company has to be able to continue operations. And so going back to the question on page 14, having a higher equity capital ratio actually lowers those obligations that a company has to make to the market, to debt holders. And so therefore it is less risky as seen by the rating agencies, and therefore it would be reflected in a better credit rating.
Okay, I appreciate that. I think the last statement there was what I was trying to ask. Which was when there's, I can pull up let me just make sure I'm not lost. I'm pulling up the transcript here. Having a higher equity capital ratio actually lower those obligations that a company has to make to the market, to debt holders. Therefore, it is less risky. So a ratio that, let's say it was, if we compared 54 to 46 to 55, 45, 55, 45, by my understanding of that, would be seen as less risky for the company by the issuers. Is that correct?
Given your question originally, I want to make sure we're really clear about the equity ratio. So an equity ratio of 55% versus an equity ratio of 54% would be seen as lower risk for from the view of rating agencies. Yes, I agree.
Okay, thank you. Thank you. And just because of what I said earlier, every time I say debt equity during our conversation, and if I give two numbers after that, the first one is the equity number and the second one's the debt, until I become momentarily dyslexic and you guys correct me. Okay, so with that established, I want to ask the question of how does a less risky debt equity ratio influence return on equity? If you have a less, my understanding, and correct me if I'm wrong, is that if you have a higher debt equity ratio, then the ability to move the ROE down relative to what it otherwise would be is easier. It's hard to ask this without, placing judgment on it. And so can you just speak to that?
Well, again, I'll talk about it through the lens of the rating agencies, because I think that might help here. So if a company were to have a higher equity ratio, and to your point of the question, therefore a lower risk, again, the rating agencies would see that as lower risk. It would be reflected in whether it's on the regulatory side or the financial side, qualitative versus quantitative. They would have comparatively a better rating because of that lower risk. And when equity investors go to invest in a company, they would see what the rating of that company is. And because that is comparatively a higher rating, they would feel more comfortable and therefore would be willing to, enter into that equity investment at a lower required return.
Thank you for that excellent explanation. Thank you. So in that context, and there's lots of testimony in the record, and there always is, about proxy groups and what the proper proxy groups are, and it's more of an art than a science by my reading of it. But my mind goes on a very simplistic proxy group, and I know it's not perfect because none of them are, to New Mexico and the utilities that exist in New Mexico. And so I did a little research, and looking at the rate cases that we've had in New Mexico since 2020, I see a 5149. Let me skip that one because I had a researcher do this for me, and that was the one case that I didn't get all numbers for it, because it just has the requested WACC. So in 2021, there was a rate case, it was 5248, and the final WACC was 6.44%. There was a case in 22 where it was 49.6 to 50.1, and then a little bit of preferred stock with a 6.47. And then SPS, it shows me here in 22, 286 had 54.7 to 45.3 with a final WACC of 7.17. There's a 2024 case that had a 51 to 48.75 with a little bit of preferred stock as well, and a final WACC of 6.9. And then, in this case, we have a stipulated, boy, I hope I didn't get this wrong. I'm counting on my researcher, 54.7 to 45.3, and a final WACC of 7.59. So
The final WACC again?
WACC, and please correct me if I'm wrong, Mr. Weiner, weighted average cost of capital.
That's correct. The synonym, acronym of WACC.
I was looking for the number, please, hearing examiner. The WACC number.
Sorry, Mr. Lees. On that last line, it was, in this case, it's been stipulated by the notes I have here at 7.59%.
Thank you, sir.
And so I'm going to focus on the 2022 cases. I have one case in which I was at 52.47 on the debt equity ratio with a WACC of 6.47. And then SPS's case was 54.7. Oh, no, actually, my note, sorry, I looked at the wrong column. Let's start that over. In the other case, it finished at a 49.6 to 50.1 debt equity ratio with a WACC of 6.47. And in SPS's last rate case, it settled at a 54.7, 45.3 debt equity ratio and a 7.17% WACC. And so what I see there is there's approximately 5 more percentage on the equity side of the ratio for SPS as to the other case I'm comparing. But then the WACC is 7.17 to 6.47, and actually this will be clearer. The return on equity for SPS was 9.5%, whereas in the other case with the lower debt equity ratio is at 9.26%. I know it's a difficult question for me to ask. You aren't an expert on another utility. But how can I understand, given what we just talked about, why would I be seeing that by 5 percentage points, SPS has a higher debt equity ratio, and then SPS also has a 0.24% higher return on equity for rate cases that were filed in the same year in the same state between somewhat similarly sized utilities?
I'll maybe start by saying I'm not looking at those proxy groups, and I don't know that you even disclosed what those operating companies were, and so it is a difficult question. What I would say, though, is that really my testimony goes to support this, is that, when any proxy group is established, it should be done so carefully. And to your point, it is some art, some science, and there's probably no perfect proxy group. What I would say is that, again, I think the facts and circumstances in any individual case should lead to the merit that's arrived at in that case. And what we don't know is the risk associated with any one of those different companies, or quite frankly, the ultimate rating agency levels that have been arrived at by the rating agencies, and if that has been determined to be just and reasonable by the commission at those times. I would also say just going back in time is also somewhat of a dangerous precedent, because market conditions today are very different than they were back then. If we look at SPS alone, I think you started with 2021, and prior to 2021, we weren't perceived to have wildfire risk at SPS. That is no longer the case. We can't go back to those times. And quite frankly, the rating agencies aren't allowing us to go back in time pre-wildfire to say, oh, that's eradicated. That doesn't exist for you anymore. And so we're at a different time and stage now than pre-pandemic. And so I would say, not only is it matter on the proxy, but it matters the time of which that proxy or that reference is being taken, and the relative risk. SPS has a lot of concentration risk. This is noted by the agencies. And in a lot of proxies, I think it's fairly unique compared to a lot of proxies or proxy companies around the country, in that there is much lower retail customers. There's not nearly as much concentration as we see here. And the agencies recognize that and perceive it to be higher risk on that factor alone. But again, as you go back, all of these things have to be taken into totality in order to arrive at a just and fair, reasonable conclusion.
And when you speak of, I think you use the word concentration, is that?
Yes.
I think I know what you're saying, but can you please explain what you mean by that?
Yes. So again, from a rating agency view, if you have a disparate group of millions of customers, each of which has a $100 bill on average every month, right? They would see that as a very disparate group and not a concentration risk. Quite frankly, the higher percentage of retail that your customer group is made up of, they would see that as a lower concentration risk. And so on the opposite, if you had one customer making up 50% of your revenues, I'm just grabbing numbers here, they would see that as very high concentration. And it's a problem because if that customer were to leave, now you have stranded asset questions that is going to drive business decisions and is going to drive onerous overhead remaining for the remainder of your rate base. So that's what I refer to by concentration. A lack of a disparate, the numbers that make it a perceived diversification in the marketplace.
Yeah, and thank you for that. And another factor I think I saw in the testimony is volatility. When you have customers that are highly dependent upon volatile markets, that increases the risk. And I believe there's testimony from SPS that oil and gas companies, for example, are in volatile markets. Is that correct?
I don't testify to the relative volatility of the oil and gas companies, but I would say that there is a market perception that probably that is more volatile than some of the other sectors on a relative basis.
So if you have a perception of, and maybe there's a reality to it. I don't know how closely you work with Miss Bulkley, but it's in her testimony, and I think she's the next witness. She speaks to oil and gas being volatile as an explanation of SPS's customer base. And you also have very large customers so you have a high concentration. That creates a risky situation that you're referring to that might help explain, what I'm seeing of higher debt equity ratios relative to other companies in New Mexico, going along with similar ROEs or even higher ROEs for SPS. Am I maybe reading those numbers correctly?
Yeah, so I would say that is probably one of a number of factors that could and is influencing risk perception.
And when SPS is called upon to serve certain amounts of demand that don't yet exist in a volatile market, did I understand it to say that does that create risk for other customers on SPS's system? For example, if one of the volatile markets created a difficult situation for certain concentrated players within SPS's rate base?
Well, I think the example that I was given is somewhat hypothetical, because I think the question that was given to me was also somewhat hypothetical around concentration and what does that mean. But in my example, if you had a single customer, which we don't have, that made up for, again, 50, something like a large percentage of your revenues, and if that customer were to leave and there weren't contractual mechanisms to make sure that they had to make certain payments on time, that could absolutely, put pressure on the system, the rest of the remaining system, and the rest of the remaining customers. So it's something we want to avoid and are very cognizant of.
Okay, and is that a factor, those contractual arrangements, that's taken into account in discussions around large load tariffs?
Absolutely, it is.
Okay, thank you. Thank you. Let me scroll through here. I think you've already covered a couple little follow-ups. So Okay, I have a couple questions about PPAs, long-term purchase power agreements. Are you, so are you, I was in a case, I participated in a case as a hearing examiner, 25-00085-UT. It was for 6 long-term purchase power agreements for battery energy storage systems. And some of the values for those battery energy storage systems were included in the application for this case. So you might be, are you familiar with those LTPPAs?
I am somewhat familiar with those, so it's not out of the range of my knowledge, although I'm certainly not an expert on those PPAs or that case in particular.
Okay. You do testify to imputed debt, though. Is that correct in this case?
To a limited extent, I do mention some impacts of imputed debt and how that would impact not only our metrics with the agencies, but overall the rating agency perception.
Okay. So in 2585, what was an interesting topic in that case that got discussed was that the terms for those LTPPAs were 15-year terms. And there was testimony in that case that raised questions with respect to why 20-year terms or longer weren't used, considering New Mexico's 2045 RPS requirement of zero carbon energy. And the explanation was given that, well, you know, if you were going to extend those terms farther on those LTPPAs, that would result in a larger classification of those LTPPAs as imputed debt on SPS's books. Are you familiar with how LTPPAs can do that and create that categorization of imputed debt?
Well, I'm somewhat familiar with how the rating agencies think about this, because I think that's the true driver, right? How they characterize this and how that ends up getting reflected on the balance sheet of operating companies as a result. Yes.
Okay. And do you advise within the company? Reviewing what your role is in the company, my understanding is that you have an overarching role that considers these financing considerations on an Excel level. That includes Excel as the holding company and also the subsidiaries that includes SPS. Is that correct?
That's correct.
So do you engage with gentlemen such as Mr. Gable that develops RFPs for LTPPAs and sets limitations for what can be entered into those RFPs due to financing considerations, of which you are an expert?
Yeah, certainly on a working group level, there is engagement to make sure that we are all aware going into those RFPs what the constraints may be from the rating agency side. And so it's not to say that it dictates what would or would not be in an RFP term. However, from my side, I want to make sure that the entire working group is aware if certain terms are included, the impact on our balance sheet as a result, and therefore our cash flow to debt metrics with the agencies.
Okay, thank you. So are you aware of mechanisms to structure LTPPAs currently? for periods of time of longer than 15 years, that would reduce the categorization of imputed debt associated with that LTPPA on your subsidiary company's books?
My understanding, and this can change with any update to methodology from the rating agencies, is that 15-year threshold has been established as demarcation for imputed debt considerations. I'm not aware of any other terms that can be altered on the backside or in addition to that to alleviate that imputed debt characterization.
Did you work with Mr. Gable on the development of the next RFP after the 2024 RFP? The 2024 RFP is the RFP through which those 6 LTPPAs were selected. Did you?
Yeah, so I did not work with him directly, but certainly with probably with members of his leadership team. Just for your awareness, I didn't join the company until mid to late 2024, September of 2024.
Okay. Do you have any knowledge as to if that new RFP was structured in a way to allow for longer term LTPPAs without the imputed debt impact? And this may be a question that we take to Mr. Gable, but I'm recalling vaguely that he said that adjustments had been made to the RFP to account for that, and that also aligned with measures that have been taken by other utilities that bring cases before the commission that were able to structure their LTPPAs in a manner to mitigate the effect of that imputed debt. Did you work with Mr. Gable to perhaps come up with those parameters in that next RFP?
I don't recall what the specific parameters of that upcoming RFP off the top of my head.
Okay. If there was a means by which to avoid that imputed debt effect, and would it be something to be pursued, considering other costs and benefits of whatever that alternative contractual structure might be?
So if I may paraphrase, it's more of a question of all else being equal. Would that be something we would want to pursue? I think absolutely. Again, as I developed in my testimony, we have to look at this at a time in place and time, right? And so I showed in my testimony that with the parameters of the current stipulation, we feel like we're going to be very close to a downgrade thresholds. That does not include some future RFPs and that the build out and the capital expenditures associated with that. And so, we feel like while this gets us to a place which is minimally acceptable at this time, it doesn't leave a lot of room going forward or like a safety margin or a safety factor to downgrade thresholds. And so going back to your question, is that something we can or would pursue? I think absolutely. It's in our best interest, and we think it's in the best interest of customers.
And to, holding a debt level constant to avoid a downgrade, some measures to avoid that downgrade and protect against that possibility would be to have a higher debt equity ratio and a slightly higher ROE. That would be seen in good favor by the rating agencies, correct?
I want to make sure I understood your question, but what I understood is that a higher debt ratio, which I don't actually agree with. So I think it's the opposite. A higher equity ratio would be seen favorably by the agencies. So I just want to make sure that I understood what I thought I heard.
Yeah, I think we're on the same page. A higher level of equity relative to debt would be seen favorably by the rating agencies. And
yes.
given.
Yes.
Okay.
So not only that, but a higher ROE. And again, in my testimony, I develop how if deciding between those, I actually think that a higher equity ratio is a more efficient source of being able to manage to a place that is acceptable with the agencies.
Yeah, I think you said it's a very powerful tool or something of that sort. Yeah.
That's correct. Because again, it positively impacts both the numerator as well as the denominator. And so there's a little more purchase or a little more leverage with the same amount of dollars getting paid by customers.
Excellent. Okay, thank you for that. You mentioned wildfire.
Yes.
And I have a note that says that at pages 22 to 23, you discuss the downgrading of SPS's credit rating due to wildfire issues. Kind of leaving that general. There's also testimony in the application that refers to the Smokehouse Creek fire. And my understanding is, has Texas brought a lawsuit, the state of Texas, against SPS in relation to, and I don't, of course you can't speak about the merits of the case or anything of that sort, but just as a factual matter, are you aware if the state of Texas has brought a lawsuit with respect to the Smokehouse Creek fire against SPS?
So I'm neither a practicing lawyer nor do I sit in our legal area within the company. Again, I'm the treasurer. I focus on financing. I'm aware of actions taken in the past by the Attorney General in the state of Texas, which I think maybe is what you're referring to, but can't speak to the status or the specific legal implications of those actions.
Thank you. I did a little research, and one thing that the Texas Attorney General, according to what I found, seeks is, and whether that will be the result or not, who can say, but let me get the right wording. The state is asking the court to prevent Excel from recovering fire costs from customers. We don't need to figure out whether that's accurate or not. I can just treat it as a hypothetical. If there were ever a determination in any jurisdiction, with respect to a wildfire, and a court ordered Excel that it couldn't recover fire costs from customers, that becomes an interesting question to me. Because of our discussion, we've talked about how if there's a higher level of risk, it influences a higher debt equity ratio, and it also influences a higher possible ROE in order to maintain ratings at the ratings agencies and not be downgraded, especially when you're at the edge of being downgraded. Given that situation, and on page 23, you say SPS's credit rating directly results in higher costs for both SPS and its customers. What kind of adjustments could be made to protect ratepayers in that situation? It's this paradox of, to maintain financial viability and good standing in front of the ratings agencies, you have these tools of ROE and debt equity ratio that result in higher rates, but then you have to protect ratepayers. So do you have a toolbox that would help you address that kind of situation?
I don't know that there's a perfect answer to that hypothetical question, quite frankly.
Okay, I know there's not a perfect answer, but what kind of tools would you look at?
Well, I mean, first and foremost, we carry insurance. So again, this is a hypothetical question. The company, as well as the parent company, carry insurance to protect against potential claims such as this. And there have been examples in the past where, if I think of this as the category of force majeure, there has been catastrophic events that some of our peers have experienced, and as a result, either utilized insurance to protect the company and customers against those costs, or potential securitization mechanisms to try and protect and mitigate the negative impact on customer bills.
And insurance, those costs would those pass through to ratepayers as well? The cost for securing insurance?
Certainly, you know, the company does currently not only observe those costs, but does it's a part of doing business. And so I would say that, yes, the expectation is that that would continue and would continue going forward. And so in the hypothetical situation, if there is a fire anywhere in the United States, which there has been, all things being equal, those insurance costs would be expected to go up. They would be expected to go up for all operating companies. And then depending on jurisdictions and perceived fire risk, insurance agencies would assess the relative measures and magnitude of those premiums.
Okay, thank you. And you know, trying to still get to like what a solution is, you know, and we're looking at that particular situation of a wildfire being tied to insurance that can be had for that. I'll start with one question, then we'll get away from it. I want to move on, but if an insurance claim is made with respect to a wildfire for which the company has insurance, and that's used as a way to mitigate effects on the rates of ratepayers, do you know how that's effectuated? Does the insurance company make direct payments to SPS, and then SPS puts a rider on its bill that lowers rates for all its ratepayers, or do you know how that functions?
So again, this is a hypothetical scenario where there is a wildfire in SPS jurisdictions and they have an actual wildfire claim against their policy with insurance.
That's an excellent description. That's better than I described it. Yes.
So my expectation is that in that hypothetical scenario, if there were costs associated with the for damages from that fire paid out for by the company, my expectation is that those insurance companies would then audit the payment, make sure it was made by the company, and for valid concerns directly associated with the policy that has been underwritten previously. And then there would be a return. Those, effectively they would make payment in kind at the same level for which the invoices have been provided and audited successfully.
Okay. And so would an actual fire and actual damages and a determination of responsibility against a utility increase the risk of that utility in the eyes of the rating agencies. You know, like here, I'll say it. If the rating agencies in their research found a determination by a court that there was a level of responsibility for a utility, would that affect how the rating agencies look at the utility?
My expectation is that it would depend on what the net impact to cash flow in this hypothetical circumstance was impacted as a result. I think the rating agencies would also, again, I think we have to say that they would take taking a step back, they would take a fulsome view of not only what is in that order or in that legal document that you just referenced, but they would look at what is the legislation and what is the regulatory body and how supportive are these in protecting the company to continue doing business in the area. And so if for whatever reason, if that hypothetical scenarios show that there were, let's say, chinks in the armor of the company where they were more exposed than everyone had previously thought, then that would absolutely have negative impacts on how the credit rating agencies think about that credit and that the credit of that company. If we rewind, we've seen this in California multiple times where it has had impacts, and the other could also be shown to be true, right? Just because there's litigation against a company, if a process proves out where there are legislative measures to protect the company, if they've done the right things and they still had a wildfire observed in their territory or jurisdiction, and or there's regulatory support that has helped protect those cash flows on behalf of the customers, the opposite could be the case where they say, hey, we've seen this proven out. This is working as planned or better than planned, and it could have a positive impact on the rating agency's perception of the regulatory landscape in which an operating company is doing business.
Okay, thank you. I think it's about time to take a bathroom break or bio break or just a morning break. I have one small follow-up question on that answer, and then one more question, and then this topic's done, just for everybody's awareness. And sorry, in interrupting myself, I just forgot my one small follow-up question, and I do want to ask it. Oh, you discussed there the mitigation, through different measures. And a few minutes ago, we referenced testimony that you have about, wildfire risk in SPS service territory being an effect upon the credit ratings. I think you also testify to how those assessments are being mitigated, and that things are solidifying with respect to how SPS is wildfire risks are being perceived by the rating agencies, that there has been improvement in the consideration of SPS by the rating agencies, specifically with respect to wildfire. Is that correct?
Yes, I would probably characterize that at least stability or relative improvement in the last couple of years. Again, as we talked about legislation, regulatory support of different kinds, they try to take it all in and make an assessment of where things are at and where things are headed. To the extent that a company has a wildfire mitigation plan on file that's approved by a commission, and is able to to take mitigating steps to harden the system in a number of ways to protect against those. They see those as very credit positive steps of the company.
Okay, great. Thank you. Then my question before we take a break. And this is why I said I kind of wanted to. So we've discussed insurance. I started this out as like, okay, if you've got pressure on your ROE and you got pressure on your debt equity ratio in order to maintain your credit rating and not be downgraded, and I started out with what tools might you have if you want to maintain your credit rating but not increase rates on ratepayers. The hypothetical is that you were ordered not to have those impacts go to ratepayers, and increased ROE and increased debt equity ratio relative to other ROE and debt equity will result in higher rates to ratepayers. And we brought up insurance as a solution, but then that's cost to ratepayers too. So then we're paying for the tool, the ratepayers are. What other tools are there? What else would you look at if we don't go to insurance? Like, if a determination is made that ratepayers shouldn't suffer higher rates in order to maintain that credit rating, and I'll give you one, and maybe there's a window there for it in that there's this at page 23 of your testimony, you say SPS's credit rating directly results in higher costs for both SPS and its customers. And in this this regulatory compact, so often costs of SPS go through to the customers, but I feel like there might be an allusion there to inability for SPS to suffer with respect to costs instead of the ratepayers automatically taking that suffering. So what tools exist?
Well, I do think that is it's a bit of a dangerous path, because I truly believe in the long term, the health of the operating company, so goes, the health of the service for the customers it provides, right? And that portion of, I think, page 23 that you referenced was not necessarily trying to separate those, but actually bring those together to say, like, these are observed at SPS, and they're ultimately passed through to customers in form of higher costs of long-term debt or the WACC, as we discussed earlier. Is there some room in between? I think in your hypothetical, probably, there would be retained earnings, which it gives limited buffer, where SPS would feel the pain or effectively pay out but not receive payments ultimately from customers. But again, in looking for a solution such as that from a regulatory body, ultimately that is going to be perceived as higher risk and a lower, tougher regulatory jurisdiction, rightfully so by the agencies. I think it'll be reflected in their published reports, and ultimately, which is why they probably go back to saying they like to see legislative protections, and they like to see wildfire mitigation plans, so that there is an ecosystem created so that a operating company who has the obligation to serve, whether that jurisdiction is in a tough wildfire jurisdiction or not, we're giving them the best opportunity to do that well, despite limitations of the weather or geological constraints that may have higher risks associated with wildfire.
Okay. Thank thank you very much, sir. I think now's a good time for a break. And hearing Examiner Schaefer, I always like his opinion on these procedural matters. What time would you like to take a break to?
Sure, let's take a 10-minute break. We're in recess until 10:35. Thank you, everybody. We're on YouTube.
Thank you.
Okay, everybody, it's 10:35. We're back on the record. Mr. Lee, are you ready to proceed?
Yes, sir.
Thank you, Mr. Lee. Hearing examiner Getco, have you concluded your questions from Mr. Vayner?
No, I have a few more questions. I'm just now reviewing. I only see one more topic, so they aren't extensive. And I have one follow-up on the prior line of questioning. And I see that we have a lot of cameras off still, so I'm pausing here a little bit. Seems like not everybody's back.
Well, that's okay. We need to proceed. We're back on the record, so the parties should be here.
Okay. Thank you, Hearing Examiner Schaefer. Mr. Weiner, can you just explain just very briefly, since we were talking about the toolbox, where I was, using that terminology of tools to protect credit ratings and not pass costs through to ratepayers. And you mentioned retained earnings is, your descriptions are excellent. And so it may take a book for me to understand that, but maybe you can give me a short explanation of how that functions.
Yeah, so retained earnings. Retained earnings, it depends on the company and what the balance sheet looks like, but it is a limited source of capital that exists within certain companies. A newly IPO'd company would not have any retained earnings, and that could fluctuate over time. It doesn't always just grow upward, but that is a source of limited capital that might hit at what it seemed like you were looking for in an answer to a hypothetical question that we just discussed.
Okay. So, okay. SPS is in an IPO. Does SPS have retained earnings?
So SPS certainly has some retained earnings, effectively. I don't know what that number is off the top of my head. But again, if we go back to how would the lens of a rating agency view this, while that could be a limited tool to help mitigate the concern I think you're trying to hypothetically address, again, I think that depleting retained earnings in that scenario would leave a company more vulnerable and less ability to absorb market shocks, quite frankly. And so, the rating agencies would view that as, in all things being equal, a higher, an increase of risk on that company, quite frankly. And so, when a company is putting in investment into those, hardening or redesign, whatever goes into the world of potential wildfire mitigation practices, the credit rating agencies view all of those very positively. And so whether it's being mandated on them or the company is proactively doing that in order to make sure that they continue to meet their obligation to serve, the rating agencies view it very favorably.
Okay. Thank you for that. My last line of question is the context is, the large amount of capital investments that SPS has to make. It's spoken about in this case, all the cases, and for SPS, and so then that brings me to AFUDC, and boy, Mr. Lee, do you need the terms for what AFUDC means, or are you ahead of me on that because of your skills and knowledge?
I'm good.
Thank you. Well, allowance for funds used during construction just came to me. Mr. Winter, AFUDC is a request by the company that has to be granted by the commission. Is it, I don't want to make a legal question. Is it your understanding that you aren't guaranteed AFUDC? That SPS is not guaranteed AFUDC?
I would not be surprised by a company response that said that is the case. Now, I'm aware that we have AFUDC currently, and in the past, we have a long history of that being approved and recovered through our income statement.
Okay. And so yeah, your direct testimony at page 26, starting on line 6. Wait, that's not right. I got that from somewhere else. I've had to move some of these questions around. And so it's only one sentence, and it's not your testimony. It says the total costs, and this is, sorry, I can go find it, but I want to, including the capitalized AFUDC, is then incorporated into the utilities rate base upon project completion, allowing for its recovery from customers over the asset's useful life. And so here's how I understand AFUDC is SPS takes on a construction project. They're granted AFUDC. SPS starts to record the amounts of funds used during construction into an account. There is a carrying cost on the funds that go into that square on the balance sheet. And when the project becomes used and useful, the cost that it took to build the project plus the carrying costs on the funds during the time of construction are rolled into a single ball and placed into rate base. Is that a correct understanding of how AFUDC works?
So I do speak, while that reference I don't think is actually mine, I agree. I do speak about AFUDC on the following 2 or 3 pages. It's maybe not the exact characterization, but I think on page 27, starting at line 6 through 9, I think has a very similar characterization to what you just laid out. So I don't disagree per se, but I did want to maybe, if helpful, point you to where I discuss AFUDC, traditional rate making.
Thank you. You corrected my citation. That's exactly it. I had the page number wrong.
Okay.
So just parsing it down just to the question about my description of how AFUDC works, and leaving aside my incorrect citation. What I heard is I described it more or less correctly how it functions. Is that right?
Correct. And maybe I could give a characterization that helps what AFUDC is, and in this case, what some of the problem of it is. So AFUDC, just to make sure we're on the same page, it gives you a way to recover those costs eventually at some point in time later. In the meantime, it is associated with GAAP earnings, which are non-cash. And so your earnings may look as if you're recovering that immediately, but it is non-cash. So in the period of construction, you don't have the same kind of cash flow that's generated from those assets because they're not yet used and useful. And again, if we think about stepping back to the lens of the rating agencies, what they really care about is cash flow. They're less concerned with GAAP earnings. They want to see cash flow and your ability to service your debt and continue operations. And so having AFUDC is helpful for companies, but to the extent that that gets really large over a short period of time, or even a large period of time, it creates a gap between cash earnings and GAAP earnings. And that can really show up in degraded metrics over the period of that construction cycle.
Yeah. Okay, thank you. Very helpful. My question then goes to this. What is the rationale? What's the justification that's provided for the inclusion of the return on of a return on AFUDC into rate base? And some of your testimony, speaking to this, when the AFUDC gets too big, well, that can be, negative. And so you turn to some testimony about, fully funding projects while they're being built so that there's actual cash flow, and that you have that in certain jurisdictions. That hasn't been agreed to here in the stipulation, but your testimony speaks about it. But just on the piece of AFUDC, and so I compare those two in my brain, and I start to say, well, how different is it? The cash flow piece is different, but from a ratepayer perspective, from that angle, it's like ratepayers are paying a return on, they're paying for a overall project cost that is larger than it would be if AFUDC didn't exist. And so can you explain to me the rationale for why a return on that AFUDC is typically granted and rolled into rate base with the base amount of the AFUDC?
Sure. So the rationale is that again, it goes back to the timing issue. The rationale is if a company is investing in infrastructure, in projects that are approved by a regulatory body, such as this one, or if we're still talking hypothetical, in the case of a hypothetical regulatory body, if those are projects that are approved, the company isn't going on their own and making their own determinations that, hey, let's do a project A, and let's put this onto rate base or on ratepayers ultimately. So the rationale is that the ratepayers are getting the service that they need and want that's approved by the regulatory body, but they're able to do it on a time frame that matches the actual cash flow and the usefulness of that asset. So rather than paying, in that example, if there was a 3-year construction cycle, an alternative would be that the company could pre-fund and raise debt and equity upfront in order to fund that construction cycle, even though the assets aren't used and useful and providing meaningful value for the customers. In this case, AFUDC provides a protection for the company. It also provides leniency for the ratepayers, so they're not making payments, cash payments, on something that is not yet used and useful, but has been determined and approved in a regulatory proceeding such as this to be useful to me in the future. And so I think that there's actually benefit of this AFUDC mechanism or some of the alternatives that I point out in my testimony, not only for the company, but for ratepayers. And so the other is that, again, this has an ability to help smooth cash flows for the company, which therefore helps rating agencies get comfortable that there is absolutely going to be, if there was billions of dollars that said company was investing, and there's a 5-year CapEx schedule, and there's not a certainty of return on and of that capital that has been invested in order to make those infrastructure upgrades, rating agencies would see that as a dramatic deterioration in the regulatory compact in which that operating company is operating.
Yeah, I appreciated that relativity for ratepayers as opposed to if they had to supply the actual cash. I've always used it if my understanding is that traditionally when recovery didn't start from ratepayers until it was used and useful, then accruing interest on this through AFUDC would be relatively worse for ratepayers as far as what they ultimately pay in rates. So if AFUDC were applied on a project versus kind of the old school regulatory compact where SPS acquired that debt and equity and pre-funded that project and then put it into rates upon completion. In that latter scenario, ultimately holding all else equal, the ratepayers would pay less if AFUDC wasn't used. Is that a correct understanding?
Yeah, so again, there's different relative comparisons. I made one example in this scenario of what an alternative could be. In the alternative, which I think you're going down, where AFUDC doesn't exist, but there's no ability to effectively have any recovery of capital raised for a project while it's in construction until it is truly used and useful. I think in that scenario, what you would see play out, especially in this case where there could be billions of dollars of capital in this upcoming and current construction cycle, effectively you'd see companies or that hypothetical company, it would be under pressure and shortly thereafterwards likely getting downgraded. And so to step back and say, oh, this is a lower cost for ratepayers, I don't think that actually takes in the totality of measures, because as we saw, several years ago with the downgrade, if you, and I point to kind of, I think 35 bips of differential on long-term debt issuances. If you take, as an example, that 35 basis points on 50% capital structure for your eventual used and useful time for that same project, it adds up to not millions of dollars, but tens of or hundreds of millions of dollars. And that's just the debt side. So again, I don't think I don't think it's appropriate to look only at what happens today, because there's going to be very negative impacts on rating agencies, your credit, and therefore your borrowing and lending costs, the cost of raising capital in the market for construction work in progress that is, by the way, still ongoing. And that's very problematic for ratepayers in the long run.
Thank you. We return to our same catch-22. Last question then, unless there's a little follow-up question to it. You're discussing, these used and useful principles and, the pressure on the company during large construction cycles. And yesterday with a couple of witnesses, visited the idea of Cunningham 2 and the fact that it's going to be closed with, rates in the future test year will take into account the depreciation expense. Given that you oversee, you work with a number of subsidiaries, have you seen trackers, riders that do the same thing for ratepayers that's being done for utilities. And I say it in this way. The utility is, gets approved for AFUDC to, help with funds that are needed during construction, et cetera, everything we just discussed. And and so that comes in before something's used and useful. And if you flip the coin over, ratepayers have a need for money in their pocket to live life and, go to the bank and qualify for a mortgage. And so they're using funds while the rates are in effect for a closed asset that isn't, used and useful. And so I'm wondering whether the regulatory community somewhere in this country is, and in particular, your experience, if you've ever seen where something's going to close, it's going to close during the time that the rates from this rate case are going to be in effect. And so instead of putting it into base rates, you put it in a rider that only collects costs up until the time that asset ceases to be used and useful. And therefore the ratepayers don't run a risk of paying in subsequent years through base rates for assets that aren't used and useful.
Yes, I think I understand the crux of your question. And by no means do I claim to be a regulatory expert across the United States on all riders for all peers or even, especially historically. Off the top of my head, I'm not aware of such a rider as you laid out. I think it probably depends on the nature of why that asset is no longer being used and useful. But the best analogy I can think of, and again, it's not a rider, but it's a mechanism that a regulatory body has proposed. And that's where, if a regulatory body were to say that you're going to close a coal plant because we no longer support the CO2 emissions that are associated with that coal plant. And that is being done before the eventual life of the end life that was planned for that plant. And a company has made that investment, and circumstances have changed such that it is deemed that it will no longer be used and useful despite their efforts to maintain it in a manner that it could continue producing energy for constituents. And in that case, that is kind of the classic example of a stranded asset and a stranded asset securitization, a use case for something like that to lower the costs. The other that I've seen is where in a similar situation, folks have utilized depreciation rates in changing and altering those depreciation rates in a manner that made sure there wasn't additional rate base that was overhanging the use and useful life of a plant beyond that time. So I think those are two mechanisms, but I don't think either directly addresses your specific question around a rider mechanism. So apologies.
No, that's excellent. And my only small follow-up on that is, the situation of it's not a coal plant. It hasn't been forced out through legislation. There isn't, undepreciated balance. It's not the legacy meters that are under consideration in this case. But it just so happens to coincide that the plant has been timed to reach full depreciation during the test year. And the rates go into effect based on that snapshot in time. And so we don't have undepreciated, we just have an expense amount for that depreciation that's in the test year, but that plant's going to be used in the time period, the entire time period in which those rates are in effect. And securitization doesn't help us with that. Alteration of depreciation doesn't help us with that. And so that's why my mind went to, maybe a rider that in the would help with that. So the last question is, are there any other solutions that address what I'm seeing there? And I view it as, on one side, it's being done for the utility, the importance of having the money in hand, but I haven't yet seen it being done on the other side.
Yeah, I'm not aware. I would probably just say that I understand the concern that you're voicing. And I would say that there's a lot, as you know, and appreciate better than anyone, that there's a lot of puts and takes that go into these type of cases. And even in this stipulation, you know, I think that there's a lot of give and takes, some of which, you know, may potentially work out in the favor of the company going forward. Others, you know, work against the company and in favor of ratepayers. I think ultimately, you know, I think where I approach it is, can I get comfortable with the equity ratio that I supported in this case? And I think that I can minimally do so, and that's reflected in my stipulation testimony.
Excellent, thank you. My apologies to everybody. I turned the page and I do have one more question. And it's, if you turn to your direct testimony at page 31 on line 11.
I'm sorry, line 11? You said?
Yeah, page 31, line 11.
Okay.
And this should be. Oh yeah, we've already referenced this testimony. You brought it up. Increasing the equity ratio is a powerful option because it simultaneously increases the numerator and reduces the denominator. This action not only improves the credit metric, but also displaces debt interest expense, reducing the financial burden passed directly to customers. My question is this, is if it displaces debt interest expense, isn't the other side of the coin that the equity interest expense goes up, thereby increasing the financial burden passed directly to customers?
So if I understand you're correct, you're saying the opposite. If you were to increase your equity ratio?
Well, what I understood you to be saying there was you're already increasing the equity ratio. That's what it says on line 11.
Yep.
I'm saying in increasing the equity ratio, you speak to how it decreases the debt interest expense.
Yes.
What does increasing the equity ratio do to the equity interest expense?
So I understand your question now. So again, if we think about the WACs that you referenced earlier, the WACCs, the weighted average cost of capital, that is a combination of your debt and equity. And so if your equity goes up, you have less relative debt. And it really then depends on what are you actually paying on that equity versus what is your actual cost of debt. And so, yes, I speak here to, you know, to the displaced debt interest expense, which is absolutely true.
Right.
There is a corollary where there is increased cost of equity that goes into an increased effective WAC for customers. But again, I think that this is not trying to say that it's costless. It's simply pointing out that as far as levers go, you know, if I were a regulator, I think there's merit in trying to understand if I have 3 different levers to choose from. I think this one gives a lot more purchase or leverage for that tool. With a small change, you get more impact on the rating agency metric that is driving the perception of credit in the market. And so, again, I think it's done on a relative basis, and I think that it is a very powerful tool for exactly that reason.
I appreciate that. Again, excellent explanation, and I really appreciate our conversation and learning from you today. So thank you very much. Thank you.
Thank you very much. Appreciate your time.
Thank you so much, Mr. Vayner. I'll just ask if SPS has any follow-up questions, given the hearing examiner's questions for you.
I do not. Thank you.
Thank you, Ms. Hardy. So time is getting tight. We want to make sure we get all our witnesses in. I'm thinking that it might be a good idea to call Mr. Gorman now, just before the lunch break. Is that possible, Ms. Miller?
I'm going to interrupt. I'm sorry, Mr. Hearing
Go ahead,
Examiner.
Mr. Gecko.
Unless you have questions prepared for Mr. Gorman, I'm not prepared at this point, and I would need to reshuffle my papers over the lunch hour, based on what was discussed at the start of the hearing today.
Okay, so we'll just wait till lunch then, and proceed with that. Mr. Vayner, I think you may be excused.
Okay, thank you very much for your time.
Thank you so much. Ms. Hardy, are you ready to call your next witness?
Yes, thank you. SPS's next witness is Miss Ann Bulkley. And I see her there in the SPS witness room.
Hi, Ms. Bulkley, can you hear us?
I can. Can you hear me?
Yes, nice to see you. Thank you for being here with us today. The court reporter will swear you in momentarily once he's able to prepare. So just hang tight and he'll be with you in a second.
Ms. Bulkley, would you please raise your right hand? Do you solemnly swear the testimony you're about to give in the matter now pending shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead.
Thank you. Miss Bulkley, can you please state your full name for the record?
Yes, Anne Elizabeth Bulkley.
By whom are you employed and in what capacity?
The Brattle Group as a principal.
And have you provided in this case SPS Exhibits 9 and 10, which are your direct testimony and your testimony in support of the comprehensive stipulation?
Yes, I have.
Thank you. And those documents have already been admitted into evidence. So with that, I have no further questions, and Ms. Bulkley is available for cross-examination.
Thank you, Ms. Hardy. Will Ms. Amer or Mr. Elliott be cross-examining the witness?
Mr. Hearing Examiner, no, we have no questions for Ms. Bulkley.
Thank you so much, Ms. Amer. I'll put the 10 minutes you reserved in your bank. Is that okay?
Yes.
Thank you. So no cross-exam, no redirect. Hearing Examiner Gecko, do you have any questions for the witness?
I only have one question, which because the last discussion with Mr. Weiner covered most things. Were you listening to that, Ms. Bulkley?
Yes, I was.
With Mr. Weiner? And so I'll just ask to you as well. Are you familiar? Have you had experience with any? Do you know of any mechanisms to track or provide another mechanism by which costs that are no longer used and useful, resources that are no longer used and useful, but that are included in rates can be accounted for? I put it, people have different opinions, but I put it as kind of a balancing equation where I see the utilities quite often argue for the need to recover costs as early as possible, especially in a large load environment. And so from the other side of the coin, in an environment when rates are being projected to go up at drastic levels, depending on who you talk to or what newspaper you read, whether there's mechanisms that protect ratepayers on the tail end of a resource when it's fully depreciated that I'm not aware of.
I did hear that conversation that you had. I am not aware of any other utility who has proposed or has had approved a mechanism such as you've described. I don't know if you have other questions, but in that conversation with Mr. Wenner, when you were talking about equity ratios, you said, I might accidentally reverse some equity ratios, and I'm sure you will all correct me if that's the case. And I would respectfully like to just offer that in that conversation, the equity ratios that you referenced that were prepared by your research associate were flipped in that discussion of the New Mexico equity ratios. And I think it would be helpful if you wouldn't mind if I just clarified for the record those two cases that you were discussing. You discussed an SPS case from 2022 and another case from 2022, which I believe may have been a P&M case, and you were referencing the equity ratio of SPS as being 54%, and then I believe you started to say the equity ratio in the other case was 52, and then you said no, it's 48. I actually am aware of those cases, having prepared to testify here today, and had been aware of the history of the New Mexico cases, so I'm quite familiar with the history. And so the equity ratio for P&M that you were referring to is actually 52%. It's not 48. So I just wanted to clarify that the difference between the two companies' equity ratios is not as large as what you and Mr. Wenner were discussing. And I think another important factor when thinking about those two cases is that the SPS case was settled, and so it was agreed to as part of an overall settlement where there is give and take for the parties, whereas the P&M case, the equity ratio was part of a fully litigated proceeding. And so I do think you likely see differences in the compromises that are made in settlements. My experience across the country is that you see compromises in settlements, and you can't necessarily take those as, precedent setting because of give and take.
Thank you for that. And so the chart that I was given showed that in the P&M case, it was a requested 52, 47.72.29. And then I was told that it resolved at a commission order of 49.61 to 50.10. And I feel your certainty. And so you're saying that the actual final capital structure that went into rates with absolute certainty was 52.48.
Yes, I believe so. The database that I was using, and I can take a quick look again at that. The database that I was using is the S&P database, and I believe that it is a 52% equity ratio that was put into rates for that case.
Well, over lunch, I can commit to going and looking at the final order in that case.
I was not reviewing the order specifically, but I was relying on the databases of historical rate case data that we typically use from Standard & Poor's. That was my data source.
Okay, I appreciate it. And yeah, absolutely. I think it's a general understanding we want to work from accuracy. So thank you for that.
Sure.
Given that you prepared, I've reviewed your testimony, and you list a number of factors for why in your argument it creates heightened risk for SPS relative to proxy groups, and those include large customers, oil and gas is volatile, smaller size of SPS, wildfire, capital expenditures, and flotation costs. If you had to pick one of those, just because we're talking, what's the most influential one?
Yeah, that's a great question. I don't think of them as being not each and every one of them is not specifically quantifiable. So suggesting that I could pick one that's most influential would depend on the circumstance, right? So certainly if there was the risk associated with wildfire is one of those risks that is very hard to quantify but is To the extent that there were to be an event, it's obviously a very significant risk. The probability of an event, obviously something less. So harder to quantify that specifically. What I've done in my testimony is to try to look at, since we're using market data for all of the proxy companies, you screen a proxy group and try to get as close to comparable as you can, and then you look at where there are differences across the proxy group. And so this was the group of mechanisms, regulatory mechanisms, and risk factors that I have traditionally looked at for the proxy group companies to evaluate differences in overall risk profile. Flotation cost is always there, so that's like a known entity. That's a known. It's not a risk factor relative to the group necessarily, but it's just a cost of issuing equity. So that exists, and it is, absent recovery, it does reduce the ability to earn the return. So that's something that always exists. But again, the rest of them are really designed to evaluate the differences in the risk profile of the company to the proxy group on a holistic basis.
Understood. Okay. That's a short conversation for us. I'll prepare more next time.
Sure.
Thank you.
Sure.
Hearing Examiner Schaefer, I believe that will be it, unless Ms. Hardy has some redirect.
I do not. Thank you very much.
Thank you, Ms. Hardy. Ms. Bulkley, you are thanked by the commission for your time and effort in this case, and you may be excused.
Thank you.
Thank you so much. Ms. Hardy?
Thank you, Mr. Examiner. SPS's next witness is Mr. Taylor Hurt, and Mr. Purcell will be presenting Mr. Hurt's testimony.
Thank you, Ms. Hardy.
SPS calls Mr. Taylor Hurt.
Thank you, Mr. Pearsall. Is Mr. Hurt online yet?
He's here. If you give us 1 second, I believe he's walking over to the witness room.
Sure, no rush. Thank you.
I am checking on him. I did see him earlier, so I assume he's walking over there, but we're making sure.
Thank you. Thank you for that.
All right, he's appeared.
Thank you. Mr. Hurt, can you hear me?
Yes, sir.
Excellent. Good afternoon. Thank you for being here with us today. I just wanted to alert you that we'll have you sworn in by our court reporter before anything else, and he will speak to you once he gets set up to swear you in.
Mr. Hurt, would you please raise your right hand? You solemnly swear the testimony you're about to give this matter shall be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir. Go ahead.
Thank you,
Mr.
Mr.
Hurt.
Hurt. Mr.
Oh.
Pearsall, please proceed. Thank you.
Mr. Hurt, can you state your full name for the record, please?
Taylor J. Hurt.
And can you state your employer and the position that you hold?
I'm employed by Southwestern Public Service Company as a regulatory policy specialist.
And can you confirm that you prepared what have been marked as Exhibit SPS 39, 40, and 41, which are your direct testimony, your testimony in response to a bench request, and your testimony in support of the stipulation?
That's correct.
Thank you, Mr. Hurt. Your Honor, Mr. Hurt's exhibits have already been admitted, so we will tender Mr. Hurt for cross-examination.
Thank you, Mr. Pearsall. I believe staff had reserved 37 minutes for cross-examination of this witness. Is staff ready to proceed?
Staff is ready to proceed, Mr. Hearing Examiner.
Thank you. Now, just for housekeeping purposes, we're at 11:21, so we might have to carry over, but I'll probably chime back in maybe around 10:05 just for some thoughts on how to organize for lunch and going forward. So thank you, Mr. Elliott. Please proceed.
Thank you. Good morning, Mr. Hurt.
Good morning, Mr. Elliott.
I don't think we've had the pleasure of meeting before, so it's good to see you. Nice to meet you.
Nice to meet you.
Your stipulation testimony, page 3, states that the accredited capacity will be adjusted for the applicable seasonal planning reserve margin. Do you see that?
Yes.
Do you have a finalized accredited capacity value for Cunningham Bess, or are you still relying on an estimate?
I am using what was available at the time of the case as presented in my first attachment in this testimony.
So that is the estimate, is that right?
Those were the numbers I was provided. I'm not sure if it was an estimate or if that was what was determined as fact.
And do you know, are those going to be, is that the final number, or is there going to be an update to that number?
It's my understanding that these numbers may change, and for further clarification on what the accredited capacity is, I would suggest you ask SPS witness Mr. Gable.
Okay. Just one moment. So, but to the best of your knowledge, we don't have that final number yet.
I don't know what is deemed final or not. I would defer to Mr. Gable.
Okay. The actual output for Cunningham Bess during the 12 system coincident peak, it could exceed its accredited capacity values. Is that right?
I think that that could be the case for any generator.
So in the case of the Bess, though, and the Cunningham Bess, if it did exceed its accredited capacity value, New Mexico customers wouldn't receive the full credit for that additional output, though. Is that right?
With this proposed method, it is set at the accredited capacity level and not at what is actually generated or outputted, but it could also be 0 at the time of the system's peak. Like, there could be no output in the system peak hour as well.
Okay, but if it is above the accredited capacity value that we have now, New Mexico customers wouldn't receive the full credit for that additional output. Is that what I understand you saying?
In terms of this stipulation, it is set at the accredited capacity amount. So in terms of the stipulation, That's right.
So what I said is correct. Is that your answer?
Yes.
Okay. The actual output, well, are you familiar with staff witness Zigich's testimony?
I have read it.
Okay. He testified that dividing an already derated ACAP value, that's the accredited capacity. Is that correct? The ACAP is accredited capacity?
Yes.
Okay, I just want to make sure we have that for Mr. Lee. That dividing the already derated ACAP value by a number greater than 1, and that's the seasonal PRM, further undervalues the resource. Do you agree? Do you agree with Mr. Zigich on that calculation?
No, and I don't agree. And if I can add that SPS witness Trowbridge speaks on that in his rebuttal testimony.
Okay, well, what's your reason for disagreeing with it?
Just it's not in the terms of the stipulation.
Well, but that's not the question, though, Mr. Hurd. I'm asking if you agree with the math Mr. Zigich is setting forth.
I think it is important to consider the planning reserve margins and direct assigned resources.
I'm going to move on. If is the PRM that you used an accredited PRM or a nameplate PRM?
Accredited.
What's the distinction?
I would have to defer that to SPS witness Mr. Gable.
Okay, so if I asked you why it matters, you wouldn't also refer me to Mr. Gable.
He is the company expert on PRMs, so.
But you used it in your
Yes.
calculations, right?
Yes.
Okay, so to the best of your understanding, in your calculations, what's the difference between those two things?
The accredited PRM is a lower amount.
Okay.
And so I think that the SPP PRMs are much higher than what is in my testimony.
And so what's the nameplate PRM?
I believe that they are just the generic amounts issued by SPP, which I'm not sure exactly how much they are. I think they're high in the winter, maybe 36% in the winter, but Mr. Gable will be able to answer that better.
Okay. So in your calculations, which one did you use?
The lower one, the accredited.
Okay. And in the results, how does the results of the calculations, how does that bear out? What's the result?
It's about it is in my attachment 1 in this testimony, and it's about a 2 megawatt decrease.
Okay. The SPP's summer resource adequacy season, that runs from June 1 through September 30th. Is that?
That sounds right.
Okay. But in your testimony, you defined summer as May through October. Is that right?
That is what is included in the calculation of this accredited capacity
Okay.
for the Cunningham battery.
Okay. And then the winter season, it runs through December 1 through March 31st?
For this calculation, those were the months used for winter.
Okay. And then, but you define winter as November through April.
Mr. Gideon, can you tell us what pages you're pointing to when you say he defines?
Just give me a second. I have to. Well, let me just ask you this. The two things aren't the same, is that right? The
What?
SPP definition for the seasonal winter is different from the one that you used.
Yes.
Okay. Well, since they don't match, can you identify the specific SPP source for the PRM values that you used in your attachment or TGH1? That's TGH stip 1.
I believe I used those since they were the terms stated in the stipulation.
Okay. Staff argues that that methodology, it's only capturing capacity benefit and it ignores the BESS's market energy value. Did your valuation account for any energy or market benefits?
In this calculation, this is a 12 CP capacity calculation only.
Okay. And you say that this valuation methodology, it's just specific to this case.
I believe that is part of the stipulation.
Okay. Would you consider the BESS a big resource?
I don't know if what the company thinks is big or not.
In your personal opinion?
I think it's only credited for 24 megawatts in this proceeding, and so I personally don't think it's very big.
Okay. Can you identify all the sources of capacity SPS used to meet its most recent resource adequacy requirements with the SPP?
That would have to be answered by Mr. Gable.
Okay. Let me just try and keep note of that. Thank you. So you in your direct at page 27.
Okay, 1 minute.
Just, yeah, let me get there as well. Let me know when you're there.
Page 27. Okay. I'm there.
This is where you calculated the system load factors.
Yes, sir.
Okay. And you calculated the system load factor using the average of the 4 peak summer months. Is that right?
That's right.
Okay. And then in your stipulation testimony that you used a single annual peak. Is that right?
Yes.
Okay. Staff witness Zigich, he testified that this change generally has the effect of favoring high capacity factor loads to the detriment of residential and small commercial customers with more variable load factors. Do you agree with that characterization?
That is the result of changing. And I'll just add, Mr. Trowbridge discusses that in his rebuttal as well.
Okay.
If I can say,
detriment, I mean, is a harsh word because the results are very similar between the two methods.
Okay. I'm going to move on to the next question. Are you familiar with case number 25-00085?
No, I don't have that case number memorized.
Okay. Does the 1CP reflect variable or growing variable energy and storage better than 4CP?
I'm not sure if there's one way that's better or worse. I think a lot of it is comes down to just judgment and specific situations within a company.
Such as?
Well, I know that the 1CP is the industry standard. Not a lot of utilities, to my knowledge, use a 4CP system load factor. So I think there's some merit in using a 1CP.
But that's not what was in your initial application, correct?
Correct.
And why was that?
I was just in my initial application following the status quo that the company has used a 4CP for some time.
And the change to a 1CP, what's the advantage to that?
I'm not too certain, so I just performed the calculations in the stipulation and would refer to Mr. Trowbridge on more detail.
Okay, thank you. I appreciate that. Just give me a moment as I'm crossing off questions, okay? If I'm just going to go back to that winter, the winter and summer seasons. If the winter and summer seasons don't match the SPP resource adequacy seasons, then can you explain the source of your PRM values that we see in your attachment stip 1?
Yes. What do you mean by the source? Because that was in it was in the stipulation that those were the
Okay,
ones.
so it was the stipulation that's the source.
Yes.
Okay. Can you identify the total accredited capacity within the test period that serves to meet the SPP resource adequacy?
I cannot, Mr. Gable would have to help you there.
Okay. On page 7 of your stipulation testimony, you indicate that SPS's willingness to participate in the stakeholder process to further evaluate the jurisdictional allocation methods, that SPS would be willing to do that. Is that right?
Right.
do you think the PRM adjustment that you're advocating for is one of those items that would get further evaluation?
Yes.
Okay. I'm gonna ask about the forecast now. Page 10 of your direct.
Okay.
Let me know when you're there.
I am there.
Okay. Lines 13 through 17. You state the method of determining cost responsibility across those jurisdictions must be consistent so the combination of costs applicable to each jurisdiction is not under or overstated. Do you see that?
Yes.
And that's still your testimony today, right?
To use a 12 CP, it is, yes.
Okay. So you're using the 12 CP and energy at source measures. Is that correct?
Yes.
Okay. Can you just energy at source? Can you explain that? Just explain what that means.
That means that the energy delivered to customers is adjusted for line losses that occur on the electric system.
Okay. It's not the unadjusted.
It is not unadjusted.
Okay.
It is adjusted.
Okay. Does Texas use that same forecast methodology?
What do you mean?
Well, to use a forecasted 12 CP and energy at source?
No.
Okay. Do you know the 12 CPs, the 12 CP and energy at source for the Texas and New Mexico jurisdictions for the 12 months ending June 26th?
That is in my testimony.
Okay. Can you just direct me to where I can find it?
Yeah, it's at the very, very bottom of my direct testimony as attachment 1.
Okay. Do you know if those numbers have been revised since your testimony was filed?
The base period numbers have not been revised.
Okay. Do you know if the numbers are weather normalized?
For the base period, they are weather normalized.
Okay.
And for the test year.
Okay. But it's possible those numbers may have adjusted since the filing of your testimony?
I wouldn't think so. Sorry.
I just was gonna try to get confirmation on which numbers you're asking about, Mr. Gideon. You've said numbers going back and forth a couple different times.
Which numbers were you talking about? Counsel, I'm sorry.
You said is it possible those numbers have changed? You talked about the base period, you were talking about FDY, and then you were going back. I just wanted to confirm that Mr. Hurt knew what he was answering.
Okay. Have you participated, Mr. Hurt, in a Texas rate case?
Yes.
Okay. And do you understand what's allowed in Texas for the development of the 12 CP jurisdictional allocation?
Yes.
Do they allow updates with more current data after a case is filed?
A part of the Texas case, there is an update period in which some is forecasted, and then there's an update period.
Okay. On page 10 of your direct, same lines, you state the method for determining the cost responsibility has to be consistent. And I already asked you that. But in this case, SPS is relying on the 12 CP measures forecasted, correct?
Correct.
And I asked you, but Texas, again, it doesn't allow that methodology, correct?
Mm-hmm. Yes.
Okay. If the commission rules on jurisdictional allocation methodology in this case, is it your understanding that would establish a precedent for the $9 billion that was approved in resources that was approved in 2566?
Objection.
Sorry, Mr. Pearsall,
It calls for a legal conclusion.
Mr. Elliott.
I can move on. Under the stipulation, residential and small general services receive approximately a 17.5% increase, while primary general service and LGST receive a 10.4. Is that correct?
Can you point me to that? It sounds correct, but I don't have it in front of me.
I think the easiest way to get it would be in Mr. Bieber, his rebuttal testimony. He has a nice table there, JB1. But subject to check, do those numbers sound right?
Yes.
Okay.
Yeah.
Do you agree with staff that residential and small commercial customers should not bear an increase greater than the system average?
I don't have a opinion on that and would defer to Mr. Trowbridge.
All right. Mr. Hurt, I have no more questions for you, and I appreciate the answers and the time. Thank you.
Thank you.
Thank you, Mr. Elliott. Maybe I'll just check with SPS counsel, Mr. Pearsall, to see if he has any redirect.
No, Your Honor.
Thank you, Mr. Pearsall. Okay, so we're getting close to noon. There's no redirect. There's no other party reserving time to cross-examine Mr. Hurt. I'll check with hearing examiner Getko. Do you have any questions for this witness?
I do. And the amount of them is going to depend on the first couple questions, because as hard as I am at working at which questions need to be asked to a witness based on answers from another witness, I don't recall exactly if I got it right for Mr. Hurt, but I have more than 10 minutes, I think.
Okay,
Sure.
well, why don't we, do you want to start, and then we can take a recess at noon and then reconvene at 1? Oh, I think you just went off audio, Mr. Getko.
Anybody?
Now we can hear you.
You can hear me now? Okay, yeah.
Yes.
I don't know what happened, but it went unstable. My microphone shut off there. Right. Did you hear me say I don't think I would finish questions with Mr. Hurt within 10 minutes? I think it would take more than 10 minutes.
Yeah, and that's fine. Do you want to start a question or two so we can take us to the 12 o'clock hour?
Sure, sure.
Okay, go ahead.
Okay. Good morning, Mr. Hurt.
Good morning.
So yesterday, I was asking some questions about the stipulation provision. Let me just bring it up. 1.11 on page 9 of the filed stipulation, originally filed stipulation. And there's a statement there that says production tax credits. It says PTCs will be allocated on an energy basis.
Yes. Okay.
Are you familiar with what that means? That the PTCs will be allocated on an energy basis?
Yeah, so like Mr. Elliott asked, what is energy at source? So it is metered energy from SPS's jurisdictions, adjusted for line losses that occur on the electric system.
And is allocated on an energy basis referring to the use of a particular allocator? And I don't want to get out over my tips and my
Yes.
skis here.
So
Yeah.
it's how much energy does Texas use? How much energy does New Mexico use? And that's what that is. And then it's allocated based on that share.
So that refers right there to a jurisdictional allocation between Texas and New Mexico?
On 1.9, what section in the stipulation?
We're on page 9, section
Okay.
1.11, the second paragraph.
Okay. The second paragraph. That refers to the customer class. And so it's the same situation there. It's how much does each customer class use, how much total energy, and then a percentage is calculated based off of that.
Okay, and so is that is it a straight percentage allocation according to a class's use of kilowatt hours? So for example, if I had 3 classes and one had, total system usage 20 kilowatt hours, there's total 100. One customer uses in the year 20, another uses 50, and another uses 30. What that's saying is that the total amount of production tax credits that are jurisdictionally allocated to New Mexico, calculated as energy at source, are then allocated by a strict percentage of energy usage according to class.
Correct. Although it is ultimately at the voltage level, which is a little bit different term than the customer class, is the voltage class.
The voltage class. Does that voltage class coincide with a particular allocator that is being used to set rates in this case, or is this a structure of allocation that is not being used to set rates?
I'm sorry, I don't understand the question.
So, and maybe because I have a incorrect premise. I'm not an allocation expert, but I hear the term energy allocator, you know, and I hear the term demand allocation, and you know, when we look at the total revenue requirement, and then it gets functionalized between distribution and transmission and generation, and then and then there's allocators that are applied to that in order to assign those functionalized costs to particular rate classes in SPS's system. Is it correct that in that process, there is something used called an energy allocator?
For PTCs, yep.
No,
that
not
is-
for PTCs, I'm sorry. For making your rate recommendation. My understanding is that you help with generate the rates. And so from taking what that revenue requirement is and getting it to what the actual rates are that show up on the tariffs, does an energy allocator, a particular one, get used during that process?
There is an energy allocator in the class cost of service.
And what's the exact name of that?
I would have to look. I think it's called energy at source.
Okay. And I'm sorry I interrupted there. I knew we were going down the wrong path, and you'd be ahead of me. And so I apologize for that. Okay, so there's an energy allocator subject to check. It's called energy at source. When I read this provision in the stipulation that PTCs will be allocated on an energy basis, will they be allocated using the energy at source allocator?
Yes, and so the term energy is commonly just assumed that it includes losses and that it is at source. And then the term sales is used to mean sales at the meter. So energy typically just means it's at source and it does include line losses.
And for our purposes here, on an energy basis means using the allocator that was used to set rates that has the title energy at source, correct?
Not talking about PTCs?
Talking about PTCs.
Oh, PTCs. I believe that those are allocated, or those allocators are updated more frequently since they go through fuel.
Okay, so what allocator is used to allocate PTCs on an energy basis?
It's the same allocator. It just is, I believe it's updated more frequently in the fuel filings.
Got it. And is there anywhere in the testimony that you're aware of where I could see on a percentage basis according to rate class how a hypothetical PTC amount would end up being allocated according to you know, 4 sample months of that energy allocator over the course of a year, so that I could understand how PTCs are allocated? And
I don't actually aggregate it from the customer class level to the voltage level. And so that exact voltage level percentage is not, I don't believe I present that anywhere. I can't recall, but there may be some filing schedules that show some of that information.
all right, it's noon. Over the lunch hour, I'm gonna, you know, this is something I've been trying to understand for a few days. I'm gonna try to write a question that will hopefully get at, you know, what I'm interested in here, and when we come back from the break, present it as a possible bench request to try to understand it, and we'll see if I'm successful over the lunch hour or not. So, thank you, and I'm gonna let hearing examiner Shaver take over now.
Great, thank you, hearing examiner Gecko. And so just for organizational purposes, Hearing examiner Gecko, I believe will have further questions for you, Mr. Hurt, after the lunch hour. So just hang tight. And once again, thanks for your patience and participation. Also, we can go into recess here at noon, which it just turned noon, and then reconvene and go back on the record at 1 p.m. I will also just say for everybody's awareness, and Ms. Miller can confirm that Mr. Gorman is available today until 3 p.m. So we'll just keep that in mind as we go through our witnesses. Is that correct, Ms. Miller?
Yes, that is correct. Thank you.
Thank you.
Hearing examiner, may I interrupt, hearing examiner Schaefer?
Yes, go ahead.
How much time has been reserved for Mr. Gorman by staff?
I believe it was 5 minutes.
That's correct.
Okay. All right. I think we can then continue with Mr. Hurt and then do Mr. Gorman. I was just trying to see where we fit that. That's how I see
Excellent.
it right now.
Great. Okay, well, unless there's any other burning issue to come between us and lunch, I wish everybody a nice lunch break, and we'll see everyone back here at 1 p.m. Thank you. We're in recess and still live stream. Okay, everybody, welcome back. It's 12:59. We're just about to go back on the record here. I believe we are going to continue with hearing examiner Gecko's questions from Mr. Hurt. So I think without further ado, Mr. Hearing examiner Gecko, if you're ready, I think we're all ready.
I need just one second. Sorry. Just one say, did somebody start a transcription of this Zoom? I just got a message with respect to that. And here, Examiner Schaefer, you can correct me if I'm wrong, but we generally don't do transcriptions from parties, and so I just wanted to triple check that.
That's correct. I would say sometimes those notices generate automatically from software. I don't see any witnesses or any transcription in the witness list or participant list.
Okay, great. Thank you. And then let me just get back. Okay. I hope you had a good lunch, Mr. Hurt. Welcome back.
Thank you.
Where we left off, we were parsing the meaning, or I was parsing, you were educating me on the provision in the stipulation that says that PTCs will be allocated on an energy basis. And we discussed about the allocator that was being applied to that, et cetera. And I said, well, maybe I can just put together a bench request. And so in doing that, I think it's worth visiting page 17 of your direct testimony. I think it'll give us the context for you to help me understand whether I've written a question down well or not. Are you there?
I'm working on it.
Okay.
Okay, I'm there.
Okay. So at line 11, you give the explanation of kind of the work that you do as a allocation expert, and you say after costs are functionalized, the costs are then classified into three categories that reflect the cost drivers. And line 17, the third of those is energy costs. And so where my curiosities have been is, the production tax credit gets generated and becomes an amount based on the generation of a particular facility, is my understanding. Is that correct?
Yes.
And that's done by looking at the kilowatt hours that are actually produced by that facility, like actual production. Is that correct?
Yes.
And so I've wanted to understand if the balance between how costs on the system, energy costs, I think, are allocated to rate classes, and how production tax credits are allocated to rate classes, and to see if there's a one-to-one ratio there in the way that they're done. And what's difficult for me to understand is how to ask that question well, because if I theorize, okay, you have $100,000 revenue requirement, I can't just say, okay, how does $100,000 get allocated through the energy allocator to each rate class? Because there's a step previous to that, which is functionalization. And so, and correct me if I'm saying anything totally wrong thus far. And so my question is, I'm trying to formulate it as, if there are $100,000 in energy costs, and those are allocated to a rate class, please provide me with the amount that is allocated to each rate class. Probably not hard for you to do. It comes down to like percentages that we see in the tables that are filed in the case. But that might be my first question to the bench request. And then the second question might be, okay, if I have $10,000 in production tax credits, and those are allocated to all the rate classes, show me how much of that $10,000 is allocated to each rate class. And I'll be able to see, starting with that energy cost bucket, how those things relate to one another. But what I don't understand is whether I should be starting higher than that and saying $100,000 revenue requirement generally prior to functionalization. Show me where that ends up in each rate class. Because for some reason to me, that feels like you can't do that. Can you do that if I say, imagine $100,000 in a revenue requirement? Show me where that ends up on each rate class. Is that something you could do if I ask that question in a bench request?
It would depend on the cost drivers. What are the $100,000 costs for the production tax credit energy allocation? Mr. Trowbridge actually has I think a perfect example of how that works for the particular PTC energy allocation process.
Oh, it does. Excellent. Okay, then I think I'll go there and speak to Mr. Trowbridge about that. And then if absolutely necessary, we could always recall you, but I can't imagine that'll be necessary. Okay, then I'm going to leave that alone for the moment. Thank you. Can I ask you just on a general question of, what's surrounding those questions is just a wanting to understand, I did some numbers and like, when you look at the kilowatt hours, that large load customers, LGST, that, I put 4 large commercial and industrial classes together, like the billions of kilowatt hours is enormous, and the rates are at like 0.002 on average per kilowatt hour. And you look at residential and you have a much smaller number of kilowatt hours used in the year per meg, and the rates are, much higher. Like, I don't know, I don't remember, I don't have it up in front of me now, like 5 or 10 times more. And so given that energy costs more for a residential or small commercial, I've been concerned that just a blanket statement of energy allocation gets tied to just straight energy usage. And therefore, it wouldn't take into account costs and dollars, because production tax credits are a combination of 2 things. It takes into account energy produced, and then it applies a cost benefit credit according to that. And so I've wondered if the allocation of production tax credits accounts for a balancing of benefits to classes, to different classes, that takes into account the different dollars per kilowatt hour that different rate classes spend. Can you tell me if you think it does or doesn't, and why or why not?
I'm a little confused on the the examples you gave with the rates, with the residential being 10 times higher. So I don't know like what rate, if there's a specific rate you were referencing or what that rate was.
So let me just put it into a different Word doc and I'll share my screen. Right, can you see my screen?
Yes. Okay. I can see.
So,
and I have a few questions.
okay.
But you can go ahead.
Well, first, just what just so you know, and I could be incorrect in the way I did this. I went to the stipulation exhibit A and I looked at what the energy charge, both in winter and summer, were for the two different residential classes, and then I looked at secondary general service, primary, and what's strictly
What's the energy rate?
Yeah, what's the
I'm
energy
sorry,
rate?
sir.
He said, "What is the energy rate?" And I said, "Yes." I said, "Yeah, but yes." And that's where I saw that difference. And I have a general understanding that like when you get to a residential class, there's functionalized demand costs that show up in the energy charges because we don't have a demand rate for those classes, and so there's a mixing. And but when I see something in a stipulation that just says on an energy basis, and I can find in the stipulation these kinds of numbers tied to energy charges,
Right, and
go ahead.
that's exactly why they're residential so much higher, is because there's a lot of capacity costs that make up that energy rate. If residential did have a demand rate, it would be much lower, similar to not quite as low as the other classes, but much lower.
Right. And so when we take a production tax credit and it's applied on an energy basis, my interest is, does it try to emulate the relative ratios of the energy charges, or does it try to emulate the ratio of, for example, energy use in kilowatt hours, which is a difference of 1 billion to almost 8 billion in the other direction?
I actually believe that Mr. Trowbridge can be of further help here as well.
Okay. All right. Thank you. Let me just save that. Okay, I had made a note to myself, production tax credit passed from Johnson, but you aren't familiar with the use of markets for transfer of production tax credits and such. I believe that's witness Coke, correct?
Correct.
Or correct. Okay. Okay, so then turning to page 47 of your direct testimony. And I'm going to get there as well. Okay. On line 1, you ask a question, which is funding for the energy affordability program included in the overall base rate cost of service. And Mr. Lee, energy affordability program here gets an acronym of EAP. And then you say the EAP will not be included in the overall base rate cost of service. It will be funded through a rider that is in addition to the cost to provide electric service. With costs and revenue tracked separately to identify imbalances. And you note that monthly charges will be recovered from all rate classes. So that's just the background. Are you familiar with Dr. Gigax's testimony?
I'm sure I read it, but I can't recall the specifics.
I can bring it up if needed, but the most significant piece that I'd like to discuss is he discusses the EAP rider on page 30, starting at line 20, going through page 31 at line 9. And he assesses that rider and he says, the resulting total annual dollars paid by all residential customers equals $405,745, which is approximately 54% of the total proposed initial annual budget of $750,000. And he says the remaining $344,255 would be paid by non-residential customers. My first question is if you have knowledge as to the construction of that rider.
Yes.
And can you tell me the rationale for the EAP is a program that's been designed to help low-income residential customers, correct?
Yes.
And the EAP is a program that's based off qualification for LIHEAP, LIHEAP, correct?
Yes.
And qualification for LIHEAP would you qualify for it at a certain income level, and if you're a couple dollars above that income level, you might not qualify for LIHEAP because it's income based, is my understanding. Is that correct?
It sounds correct. Yeah, I'm not an expert on LIHEAP.
So in designing the rider for the EAP program, were concerns addressed with, I'm going to say it just looks a little odd. It's a program designed to accommodate residential residential rate class, which includes folks that are, just above qualifying for assistance for the program, are included in a group that is paying 54%. Whereas, I think if we brought up that document that I just brought up and shared the screen on, we'd see overall cost paid in a year. Like, I can't imagine a residential class pays 54% of the revenue requirement for SPS. And so can you talk about why this balance was constructed in this way, that this amount was assigned to the residential class?
The allocation of the program cost was a mix between how much customers are in each rate class, and that is
Sorry, how much customers are in the what class?
rate
Thank you. And
the cost of service for each rate class. And so I believe the customer count allocation is 75% of the allocation, and then cost of service is the remaining 25%. And that seems like a reasonable weighting. This was the original proposal in SPS's last rate case. And so I followed the status quo and did the same calculations in this case.
And when you go to a weighting by customer account on SPS's system, that's always going to end up with a greater weighting towards residential class, because like we talked about with Mr. Wayner, there's a concentration of very large load customers, which means a smaller number with high energy usage. And that's a small number compared to a relatively large number of residential accounts. Is that a fair understanding?
Yes.
Hearing examiner Gagco.
Yes, Mr. Pearsall.
Sorry to interrupt, but I just want to ask, I'm having trouble as you talk about Mr. Gigax's direct to obtain that from the Dropbox. Is that in the Dropbox, that piece of evidence?
I would need to check. The answer is going to be no, based on the conversation that we had with NMDOJ's counsel this morning.
Okay, because I just wanted to make sure, because I know the MNDOJ asked about filing testimony in support of the stipulation post, but I wasn't aware that they were not also uploading the direct as part of the record. And so I wanted to make sure Mr. Hurt and you and everybody else had a chance to review it as you were talking about it.
And I can bring that up on screen. That's a really good point. And also clarify that, my intention with that discussion with NMDOJ counsel this morning was that we arrive at an uploading of the direct testimonies. I did not, though, because of other things on my plate, consider, is that link still available? What was the timeline for that to be done? Perhaps DOJ counsel, if you could attempt to do that over the next hour and then report back on whether you're able to upload it to the Dropbox, would you be amenable to that, or would you need more time than that?
Hearing Officer Gedko, we'd be happy to do that, but I've been told by your administration the Dropbox is closed and nothing can be entered into it.
I think as a workaround and a variance from our order regarding Zoom protocol and exhibit exchange, if you are able to label the direct testimony properly and email it to the entirety of the list to which I emailed on Friday, my list of witnesses that I would like to ask questions to, that would suffice in this case. And then hearing examiner Schaefer and I can take it from there and make sure that it gets into the possession of Mr. Lee.
Happy to do that, Hearing Officer Gedko. We'll work on that right now.
Thank you.
And thank you, Hearing Examiner Gecko. I just want to make sure we're all working on the same record as we go forward.
I appreciate you stepping in with that. Thank you. And I'm gonna source that testimony really quickly and bring it up on the screen so and that we can be sure we're talking about the same thing. My paranoia is, am I still sharing my screen? If I am, you can yell at me, somebody, please. Okay, I'm going to share my screen now. Thank you for being patient with me. And the quote I had pulled was from page 30. Starting at line 20. So starting here, and this confirms what Mr. Hurt recounted, that it's based on a 25% weighting of the class cost of service and a 75% weighting of the class's customer count. And then here's the remainder of the testimony that I referred to, going through line 9. And I think the last question I asked was just as a general, when given the construct of the SPS's customers, when something's done on a weighting based on a higher towards a class's customer account, holding all else equal, that would result in the residential class having the largest allocation, because the number of accounts in the residential class are greatest amongst all as compared to all other rate classes. Is that correct?
Yes.
I may share my screen in a second again, but I need to be able to move a couple things around. And so beyond just, when I asked, is there, I said a rationale, I think is probably what I said, but for assigning costs in that way, and you pointed me correctly to how it was done, 75, 25%. Was there consideration on your part or in discussions you were in as to whether that's an appropriate balance as to allocation for a program that aims to benefit low-income residential customers?
I think that is why the 25% is weighted on cost of service to balance it out. And I recall, I think it was, I put together a bill impact for this particular charge. And I recall them being fairly similar bill impacts because it is only a 35-cent charge for residential. And so I recall the bill impacts being very similar among all of the classes.
So like a very large customer would have a 35% bill impact as well, or am I
On a
misunderstanding?
percentage basis. They
On
would,
a percentage.
the percentage basis is very similar.
Okay. Okay, that's helpful. Okay. Do you know where that testimony might be?
I think it was in a discovery response.
Okay. Are you able off the top? I mean, how certain do you feel about that? I mean, because if it's a discovery response, it's probably not in testimony.
It is not in testimony. It was a discovery exhibit, from what I recall.
Can you consider that SPS counsel as a bench request to provide a short document that shows the bill impacts of the EAP program by rate class, please? That's Mr. Pearsall, correct?
Yes, sir.
Did you understand the request? I just wanted to make sure I
Yes, I
spoke
did.
clearly. Okay, thank you. Let me get my questions back here now. Okay. Those are all my questions for you, Mr. Hurd. I appreciate your responses and helping me through some things that I feel are helpful when I consider the case. So thank you very much.
Yes, sir. Thank you.
Mr. Pearsall, do you have any follow-up questions for the witness?
No, I do not, Your Honor.
Thank you, Mr. Pearsall. Okay, Mr. Pearsall, I believe you may be excused. Thank you again for all your time and dedication to this proceeding.
Thank you, Your Honor. I believe while I'd like to be excused, I think you should excuse Mr. Hurt. He'll thank you more than I will.
Thank you. Well taken. Mr. Hurt, you may be excused. Please stick
Thank
with
you.
us, Mr. Pearsall. Okay, so now we have, I think, the necessity to hear from the witness, Mr. Gorman. Is that correct? Hearing examiner Gecko, would you advise that?
Yeah, I agree. That's my understanding as well, given the 3 o'clock time frame. And I believe staff has requested 5 minutes, if I remember correctly.
Great. Okay, Ms. Miller, is your witness ready?
I have instructed him to log on, so
Okay.
hopefully he'll be here shortly. And I will just go ahead and introduce his testimony and save the remaining.
Sure.
Okay. I'm going to call him and make sure he saw my message. Mr. Gorman said he's waiting to be admitted.
Excellent. Okay, I'm admitting him now. Ms. Miller, before we get started with the witness, do you just want to go ahead and enter LES FEA exhibits that were uploaded into the record?
Sure. Yes.
Great. Yeah, let's go ahead and take care of that. Go ahead,
Okay.
Ms. Miller.
Yes, FEA and LES have 3 direct testimony exhibits from witnesses that will not be testifying. That is, and we have 6 exhibits total. FEA and LES Exhibit 1, the direct testimony of Brian Andrews.
Are there any objections? It is admitted.
FEA and LES Exhibit 2, the direct testimony of Matthew Smith.
Are there any objections? It is admitted.
Okay. FEA and LES Exhibit 3, the direct testimony of Michael Gorman.
Are there any objections? It is admitted.
FEA and LES Exhibit 4, the direct testimony of James Lako.
Are there any objections? It is admitted.
FEA and LES Exhibit 5, the direct testimony of Christopher Walters.
Are there any objections? It is admitted.
And FEA and LES Exhibit 6, the settlement testimony of Michael Gorman.
Are there any objections? It is admitted. Thank you, Ms. Miller.
Thank you. Okay.
Okay, so Mr. Gorman, are you here with us? Can you hear me?
Yeah, yes.
Excellent, thank you. Good afternoon, thank you for being with us. I'll just say, as I always do, the court reporter will swear you in momentarily once he gets settled, and then he will issue the oath. So just hang tight and he'll be right with you.
Thank you. Thank you for taking me out of order. Appreciate it.
No problem.
Dr. Gorman, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, please.
Thank you. Could you please state your full name for the record?
My name is Michael Gorman.
Okay. By whom are you employed and in what capacity?
Employed by Brubaker and Associates, BAI, as a managing principal.
Okay. And as Mr. Gorman's testimony has already been admitted, I will open him up for cross-exam.
Thank you. Ms. Miller, just before we do that, did you want to ask Commissioner O'Connell's question?
Yes, thank you for reminding me.
Sure.
Yes, before we begin your cross-exam, Mr. Gorman, I'm going to ask you a question posed by Commissioner O'Connell. As a witness testifying on behalf of FEA and LES, how do you view the fairness of different rates being paid by customers in Texas versus customers in New Mexico?
I believe they are developed in a similar manner across all three jurisdictions for SPS. The jurisdictional allocation methodology separates transmission and production common costs, which serve all three jurisdictions, based on load characteristics, which define how much production and transmission capacity SPS needs in order to provide service to all three jurisdictions. Within the two retail jurisdictions, New Mexico and Texas, there are some differences in the development of class cost of service and the design of specific rate schedules, but I believe they're reasonably similar to one another. And the methodologies employed in both jurisdictions have the effect of designing rates which reasonably reflect SPS's cost of providing service to different types of customers with different load characteristics. Believe the revenue requirements that have either been determined to be appropriate by the commission or are based on settlements that are approved by the commission reflect reasonable cost of providing service. And based on that, I think the rates that have been approved in both New Mexico and in Texas are reasonable for the provision of service from SPS.
All right. Thank you very much. Mr. Hearing Examiner, I would open Mr. Gorman up for cross-exam at this time.
Thank you. Staff, I believe you had reserved 5 minutes for Mr. Gorman for cross-examination. Is that correct?
Yes, Mr. Hearing Examiner, and I'll be asking the questions for staff. And I'm going to request an additional 7 minutes from our bank of minutes.
Sure.
If that's okay.
Yeah, thank you, Ms. Hamer. And let me just, so a total of 12 for Mr. Gorman. And let me just provide the accounting there on how much you have left with that 7 minutes for attributed to this cross-examination. So that'll be 36 minutes that you have left over.
Oh, thank you very much.
Thank you.
Good afternoon, Mr. Gorman. My name is Judy Amer, and I'm an attorney for the legal division at the New Mexico Public Regulation Commission, and I represent the utility division staff. I'd like to direct you to your testimony in support of the stipulation. In particular, oh, great. I hope my computer is freezing. I'd like to go through the terms of the stipulation and ask you to talk about how it compares to your direct testimony recommendations. So on page, I'll make sure this is the right page. Not getting the pages, but it appears to be on page 2 of your testimony in support of the stipulation. You talk about the revenue requirement being adjusted to 90 million. How does this compare to your direct testimony?
In the direct of the witnesses sponsored by FEA and LES, the $90 million is a reasonable resolution of a revenue deficiency for this utility within the constructs of the future test year in this case. It reflects a rate of return which we believe reasonably aligns with the current capital market costs for common equity for SPS. It reflects the...
No, I hate to interrupt you, Mr. Gorman, but I just want to go like step by step. So was that 90 million less than or more than what your clients recommended?
I kind of have to answer that with a condition, because frequently when we sponsor adjustments to the major issues in the case, when we come to the briefing stage, we typically expect that we will endorse other parties' positions in identifying what a reasonable revenue deficiency, if any, exists for the utility. But the $90 million in the settlement in this case is reasonably consistent with the adjustments that we proposed to the company's cost of service in this case.
Okay, thank you. And with respect to the stipulated ROE of 9.5%, is that higher or lower than what your clients originally recommended?
It's within the range of return on equity we recommended, and very close to the point estimate recommended by LES FEA witness Mr. Walters.
So is it the position of your clients that with respect to those two terms, the stipulation is beneficial?
It's a balanced and reasonable outcome to the rate case, yes.
With respect to the jurisdictional allocation for the Cunningham battery energy storage, how does that compare to your direct testimony position?
In this case, we didn't directly address the allocation of the Cunningham resource, but we did in prior cases where they sought CPCN for Cunningham. The issue with the Cunningham is it was necessary in order to meet the renewable target mandates for New Mexico. It wasn't necessarily the best resource option for meeting Texas resource portfolio needs. So the direct allocation of that or direct assignment of that resource to New Mexico was reasonable, given the costs were incurred to meet a regulatory mandate. And that the adjustment to the jurisdictional allocation to reflect the accredited capacity benefit of that resource that will be also directly assigned to New Mexico produces a reasonable outcome
Thank you.
for allocating those costs.
Regarding revenue allocation and rate design, does the stipulation is the revised revenue allocation and rate design beneficial to your clients?
We believe it's a reasonable resolution of the issues in this case. The class cost of service study with respect to transmission and production costs does reasonably align with cost causation. We think it's fair and reasonable. The design of the LGST rate reasonably aligns with the allocated cost to that rate class and the functional breakdown of those costs between demand, energy, and customer components.
Is it correct that the class of customers that your clients are in will get an approximate 10% increase?
That is correct, yes.
And
in non-fuel based revenues, that's correct.
right. And is that beneficial to your clients?
Well, a rate increase isn't beneficial, but it's a fair resolution of the outcome of this rate case.
And do you know how the stipulation benefits the residential ratepayers?
I believe all customers benefit by agreeing on a revenue requirement and revenue deficiency that reasonably reflects efficient and economic management of the utility. And is spread across the rate classes based on load characteristics, which describe how the utility incurred costs to provide service to each of those rate classes. So while no rate class benefits from a rate increase, I believe it's a fair resolution to all rate classes.
Are you aware that as compared to the 10% increase to your client's rate class, residential customers receive a 17.9% increase?
I do, and that still leaves that class below cost of service. So the spread is a gradual movement towards cost of service, but moderates the increase to all rate classes in order to avoid rate shock.
And you believe that resolution is fair, just, and reasonable?
Yeah, it's consistent with long practice in New Mexico for this utility, from my experience, and I believe it is a fair and reasonable resolution of the issues in this case.
For that, you mean that the 17.9% for residential compared to the 10% for the LGST classes?
Well, yes, but more specifically, the movement of each rate class towards cost of service while moderating the increase to any specific rate class so as to avoid rate shock.
Thank you. I have no further questions.
Mr. Hearing Examiner, I think you're on mute.
Thank you. Sorry. Thank you, Ms. Amber. By the way, you have 4 minutes remaining on your time, so I'll put that back in your total number of minutes remaining. Thank you, Ms. Amber. Ms. Miller, do you have any redirect for the witness?
No, I do not. Thank you.
Thank you. And I just wanted to check if Chairman O'Connell has any questions for the witness.
No questions from me. Thank you.
Thank you, Chairman. Hearing Examiner Getko, do you have any questions for this witness?
I have just a couple short questions. Good afternoon, Mr. Gorman.
Good afternoon.
In the questioning just now, and I don't have the transcript up, you testified to reasonableness of the stipulation, and that includes an ROE, for example, and a jurisdictional allocation would it have been reasonable for the result of the stipulation to result in a 3% rate increase greater than what the stipulation has for your client, LES, FEA?
For a revenue deficiency of greater than $90 million. Would have to consider the other aspects, but based on the give and take within the settlement here, the $90 million was a point where we felt it was a reasonable compromise of the contested issues in the case.
And if your client's share of that $90 million were to change by 3%, would you need to consider whether the stipulation is still in the interest of your client and look at some math and make a determination?
That decision wouldn't be made by me, but it'd be made by the parties I'm representing. But we would certainly look at those circumstances and respond to whether or not any change of the stipulation would have any impact on whether or not we continue to participate in this stipulation.
Your client, do they have facilities that operate both in Texas service territory of SPS and in New Mexico service territory of SPS?
No, sir. My clients operate only in New Mexico.
Only in New Mexico. Okay, thank you.
Thank you.
Those are all the questions I have.
Thank you, hearing examiner Gecko. Ms. Miller, do you have any follow-up questions for Dr. Gorman?
No, I do not. Thank you.
Thank you. Well, I don't believe anybody else had reserved time to cross-examine this witness. So, Dr. Gorman, thank you so much for your time and dedication to this proceeding. You may be excused.
Thank you very much. Appreciate it.
Thank you. Okay, so I believe now we can get back to SPS and the presentation of their witnesses. Ms. Hardy or Mr. Pearsall, who is your next witness? One second. Yes, Mr. Elliott.
Mr. Hearing Examiner, thank you. I just wanted to ask, after we have Mr. Trowbridge, what witnesses are we expecting to get to through the rest of the afternoon?
That's a good question. I see that staff has 27 minutes for Mr. Trowbridge, and there's no other party requesting cross-examination time for that witness. So I think it depends on what hearing examiner Getco has in mind in terms of time. So maybe he can share with us a ballpark figure.
Well, I just mean for the availability of witnesses that could be called this afternoon.
Well, I think we'll have to get through Trowbridge, and then there are a potential 4 other SPS witnesses on their availability on day 2. I believe that all of them are available except Mr. McGregor. Is that correct, Ms. Hardy?
That's correct, Mr. Examiner.
And the order, or could you just restate them for me so that I know I don't have my notes from yesterday.
No worries. No, we all help each other stay cool and stay organized and calm. So the remaining SPS witnesses are Mr. Alexander Trowbridge, Megan Scheller, Paul McGregor, Justin Gable, and Laura Brennan. Now those remaining 4, the last 4, that is Scheller, McGregor, Gable, and Brennan, are available potentially in case the commission or hearing examiner Gecko or I have questions for those witnesses. So their presence may depend on that determination, which hearing examiner Gecko and I will let the parties know shortly. So does that help you, Mr. Elliott?
Yeah, absolutely. I believe we reserved 15 for Mr. Gable, so I just wanted to.
That's right. Yes, there was, you added that extra 5 minutes to Mr. Gable. That's correct, Mr. Elliott. That's what I
Okay.
have.
Okay. Very good. Thank you, sir.
Sure, excellent. Okay, Ms. Hardy and Mr. Pearsall, are we ready?
Yes, I am, Your Honor. SPS calls Alex Trowbridge.
Excellent. Hi, is that Mr. Trowbridge? Can you hear me?
Yes, I can. Can you hear me?
Yes, good afternoon. Thank you for being here with us today. As you may remember, our court reporter will swear you in, and he just will get settled with a few items, and then he will reach out to you.
Thank you.
Mr. Trowbridge, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter and opinion should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead.
Mr. Trowbridge, can you state your full name for the record, please?
My name is Alexander G. Trowbridge.
And Mr. Trowbridge, by whom are you employed and what is your position?
I'm employed by Excel Energy Services, and my position is Director of Pricing, Regulatory Pricing and Analysis for SPS.
And Mr. Trowbridge, you prepared what have been marked as SPS exhibits 42 through 46 and exhibit 49. And these are, just for your reference, it's your direct testimony, your supplemental testimony in response to bench requests 1 through 3, your testimony in support of the comprehensive stipulation, and your rebuttal testimony in support of the comprehensive stipulation. Is that correct?
That's correct.
Okay. And with regard to what has been marked as SPS Exhibit 49, and this is your rebuttal testimony in support of the stipulation, in preparing for today, did you identify a potential correction to that testimony that you'd like to make on the record?
I did present, or I did identify a small correction.
Can you go over that for the record, please?
On page 8, row 2 and 3, at the end of row 2, that said present calculation, and that should say present revenue calculation.
Thank you, Mr. Trowbridge. And Your Honors, we have a copy that has the additional word added to it. We can upload that and replace it in the Dropbox, or we can leave it as is corrected on the record here. It's just that one word that was misplaced.
I think we should have the corrected version uploaded just for thoroughness. And Mr. Pearsall, I'll work to generate a upload link for the Dropbox.
Okay.
And share that with the parties so that in the case there's other corrected testimony that comes here in the next day or so, there won't be any problem uploading that that testimony and that exhibit.
Okay, thank you.
Sure,
and
thank you.
Thank you. And lastly, before we tender Mr. Trowbridge for cross-examination, we wanted to, with Your Honor's permission, answer Mr. O'Connell's, or Chairman or Commissioner O'Connell's question regarding the differing rates, and just have that on the record if that's permissible.
Absolutely. Please proceed.
Excellent. Mr. Trowbridge, have you been watching the hearing today?
I have been.
And you're aware of Commissioner O'Connell's question regarding the fairness of New Mexico and Texas customers paying differing rates for service from SPS?
Generally, yes. I missed that particular request.
Okay.
But I understand that there was a request.
Okay. And do you have any comments that you'd like to provide regarding that question?
Yeah, I can weigh into that and provide some additional information.
Thank you.
I thought Dr. Gorman did a good job of going through and describing the mechanics generally, and the resolution under the stipulation. To add on to that, generally, between our jurisdictions, we allocate costs. It's very common amongst many utilities to allocate costs on a 12 CP basis. That is essentially our starting point. So it is the combination of that, the revenue requirement, which is the cost to serve customers, fair and reliable service. And so we come forward with our system and the cost to go through serve customers. We allocate that jurisdictionally. And then ultimately that makes its way down through rate design. For us, we typically employ first a class cost of service. The major components are allocated based on AED 4CP, and then also energy allocators. And then on top of that, gradualism has been employed, for a number of years in this jurisdiction, and that is to say the allocation of costs between the jurisdictions and then down to the customer level are applied on a mechanical and traditionally sound regulatory basis, and then on top of that, there are elements of affordability and gradualization that for instance, would reduce the cost allocation to customers that otherwise would have had a larger increase, for instance, to base rates.
Thank you, Mr. Trowbridge. Oh, sorry.
And then just one more point was just to mention, for instance, for our residential class, residential rates in New Mexico since 2021 have been lower than they are in Texas. So just to keep in mind that New Mexico residential customers, for instance, are not paying higher rates than they are in Texas since 2021. Obviously, as we come through a rate case, base rates have not been adjusted in this jurisdiction, and so when they go into effect in December under the stipulation, that would be 3 years since the last rate update in this jurisdiction. And obviously, this is a significant case. So there is some catching up that's going on right now for this jurisdiction.
Thank you, Mr. Trowbridge. And are there, just briefly, are there any key differences between the two states that makes the comparison that we're discussing difficult?
There are fundamentally the two jurisdictions. So first off, you have to think of each jurisdiction and base rate filing as being a snapshot in time. And that is to say that in Texas, base rates were last established based on a 2022 test year, for instance. So there, and then also in Texas, there are different rider mechanisms that bridge between the base rate test year and current rates, so that they will adjust essentially over time. Other items that are different between the jurisdictions is that you have different approved depreciation rates. You will have different approved equity authorized returns, and potentially different equity weightings as some of the other differences. Also, for instance, in New Mexico, we have different rider mechanisms like the RPS, where we have a policy requirement for renewables in New Mexico that Texas does not have. So comparability is not entirely simple.
Thank you, Mr. Trowbridge. And with that, hearing examiners Schaefer and Gedko, SPS tenders Mr. Trowbridge for cross-examination.
Thank you so much, Mr. Pearsall. And I turn now again to staff, who had originally requested 27 minutes. Mr. Elliott, Ms. Amer, is that still the amount of time you wish to use, or do you wish to add any to that?
Mr. Hearing Examiner, right now, I think we can do this in 27 minutes, but if I need extra time, please let me know when I'm getting close and I will request it.
Absolutely. I'll give you a 2-minute warning, and please proceed. I think maybe Hearing Examiner Gedko, do you have a quick question to ask the witness?
I do, and I've seen this in the past that when we're on a topic, every once in a while, a hearing examiner will step in, and so if I may, sorry, Miss Amer, and somebody has their YouTube on. We're getting some feedback here. Testing. I think it's been fixed. Good afternoon, Mr. Trowbridge.
Good afternoon.
I just wanted to step in with one thing, and I'll try to visit with the chair this evening, or if I am able to outside of this. But when he spoke this morning and introduced that question and asked for it to be answered, he gave as simple of an example as, you got a family member in Roswell, and then you got a family member in Amarillo, and what am I supposed to say when that family's standing in front of me and ask me why they've got different rates? And so your explanation was very excellent for those of us sitting here in this hearing. But I understood kind of that, and I'll verify with him, but and so just ask, it's my question now. What would you say kind of to somebody that has no idea about allocation and revenue requirements and rate cases, and are you able to address that of fairness of rates on that on kind of a broader higher level?
I think that, and can you hear me?
Yes, I can. Thank you.
Okay. So I am I'm a pricing and cost allocation professional. And so I know these issues, and I can go into greater detail. I think between the two jurisdictions, so when we talk about residential customers or small commercial customers, the rates are very close. They're on parity, I think, through time. And the reason, in many ways that they are very close, is because we employ the same methodologies to develop at least the cost of service and the way that rates would be developed. Gradualism is applied maybe a little bit more aggressively in New Mexico traditionally. And so that's part of the reason why I believe that Texas rates might be higher. But just between those two, the goal of rate making, right, is to introduce, to present cost causality, right? It is, what as a class, how does this group of customers, how do they use the system, and then allocate the costs on that basis. As we start to move through this case in particular, the types of things that we see driving costs is we see a couple of different issues. We see inflation generally, and those are things that are going to be picked up. We also see an aging infrastructure, an aging system where we have unit replacement that's taking place. And then we also have things like in SPP, we have changes to the planning reserve margin, for instance. So when we think about changes to the planning reserve margin, it isn't something that sits on its own. It's something that we reflect on in terms of, for instance, Winter Storm Uri, and we look at how utilities need to harden their system to ensure reliability. And I believe, this is not an area that I'm steeped in, but I believe that the changes that we're seeing in terms of winter planning reserve margins, those are coming about to ensure reliable service. And it is a reflection of what we've seen in terms of unit availability during constrained time periods.
Okay, thank you.
Yeah, thank you.
Okay, thank you, Hearing Examiner Gecko. I'll say that we're about an hour and 12 minutes in to our afternoon half of the day. So I think maybe this is a good time to take a 10-minute break, start fresh with staff's cross-exam. Everybody get some fresh air and stretch a little bit, and we'll resume at 2:21. So we're in recess until 2:21. Thank you, everybody, and YouTube is still live and streaming.
Yeah, hi, it's Judy Hamer. I have a quick.
Judy, your camera and microphone's still on.
Okay, good afternoon, everybody. We're back on the record at 2:21 p.m. in our afternoon session for day 2. I believe we were just about to resume cross-examination with staff. Is that correct, Ms. Amer? Ms. Amer, can you hear us? Mr. Elliott, are you there?
I am. Let me just try and raise her. I know that we were just
Sure.
on the phone preparing, so just one moment.
Okay, no rush. Thank you. Ms. Amer, are you ready to proceed?
Yes, thank you.
Excellent, thank you. So I have 27 minutes. You may begin.
Okay. Good afternoon, Mr. Trowbridge. You know me, we've met in other circumstances. I'm Judy Amer. I represent the legal division and the NMPRC utility division staff. I would like to ask you about some information that staff has indicated in their testimony that they would like to see. And it has to do with the allocation of the revenue requirement. Is it correct that SPS uses the 12 CP forecast for both Texas and New Mexico?
The company uses the 12 CP methodology for cost allocation of production and transmission resources
Right, and
in both jurisdictions.
both jurisdictions. And you provided forecasted information for both Texas and New Mexico, which indicated approximately 30% for New Mexico and 9% for Texas.
Could you point me to those statistics?
I'm sorry, but I was just speaking with our expert who told me that. So I cannot right now point you to that, but you do
Okay.
agree that using the 12 CP forecasted a greater amount for New Mexico than Texas.
I would have to look at that specifically. My recollection is that it results in close to 50-50 allocation between the two jurisdictions.
Okay. Is it possible for SPS to provide the parties in the commission with the actual energy usage per jurisdiction up to today? So, in other words, 12 months of data showing actual CP for Texas and New Mexico to confirm that the forecasts are correct.
I understand the question to ask if we could provide peak by total peak and then go through the jurisdictional allocation process.
For 12 months prior to today to confirm that SPS's forecasts are correct.
It typically takes the utility about 2.5 months to update. So for instance, if we were looking for a 6/30 period end, we could analyze that. We could provide that analysis, a 12 CP based on sales and load for the system, we could analyze that in early September. We could provide that statistic.
Just a moment, please. Just a moment. When you say 6:30 period to end, is that 6:30 or 6/30?
Yes, June 30th. So if
Thank
that
you.
would be, yes, 6:30 being June 30th.
Thank you.
Thank you.
Objection.
Mr. Pearsall, what's your objection?
I just want to confirm, are we being asked to prepare discovery 2 months from now? I'm trying to understand the relevance of providing additional information at this date beyond the forecasted test year.
Okay, so Ms. Amer, what's your response? What is your question and your response to the objection?
Thank you. This is not discovery. We are asking if SPS could provide the parties in the commission with its most current data. It sounds as if Mr. Trowbridge is saying it wouldn't be able to June 30th, but it might be able to April 30th. And so we're just
Okay,
asking,
so your question, Ms. Amer, is not a request per se. You're asking, would it be possible? Is that correct?
yes.
Okay, can you restate your question then in that manner?
Is it possible for SPS to provide the parties in the commission with actual energy usage up to whenever they have it calculated? It sounds like not up till today, but up till April 30th.
The company has the ability to calculate 12 CPs based on data that's available to it.
And would the company be able to compare it to the forecasts?
Objection.
Mr. Pearsall?
Again, it's possible that the company can do updates of its entire case. I'm trying to understand of what's the relevance at this point, because we have data in the record of the FTY, the base period. We can update everything if we wanted to, but I don't know how that's relevant at this point.
Okay, so the basis of your objection is one of relevance, is that correct?
Yes, sir.
Ms. Amer, how do you respond?
I would say that it is relevant because we all agree that forecasts are forecasts and they're not actuals. And therefore, there's no way to confirm whether a forecast is correct without looking at actuals. But the commission should or could, it appears to be in the public interest that the commission know whether the forecasts are supported by actual, most recent that they have data.
Okay, so Ms. Amer, you're essentially asking, is SPS able or has it checked its forecast with past actual data? Is that correct?
I don't know if they have. I was just asking if they could, if they were able to do that, if the commission asked them to do that.
Okay, well, let's just focus on that first question. I do think I'll overrule the objection. I think on a limited fashion it is relevant. So Mr. Trowbridge, is SPS able to compare actual data versus forecast data?
So for the purpose of analyzing the forecast period, obviously we don't have any actuals in that period. So that the forecast test period ends in November of 27, begins in December of 26. And so we wouldn't have any actuals to compare to that period. I don't know that that would facilitate a conclusion as to the accuracy of the forecast.
How would you confirm the accuracy of a forecast?
Well, you might be able to you could compare forecast actuals in recent history, potentially.
Has SPS performed any such comparison in this matter, or related to this matter, that is, forecasted actual data?
Yeah, as I stated, obviously this forecast this forecast test period begins in December of this year and goes through November of next year. And so there are no actuals to compare to that period yet. I think that our forecast teams, it's not my area of expertise, but I believe they do some comparisons to actuals in terms of when they go through and they're updating their forecast. Excuse me.
Go ahead.
I was just going to say, generally speaking, it's possible to compare actual sales to a recent vintage forecast if you wanted to understand that. That would be my recommendation, but it's outside of the scope of my testimony. I'm focused on with my team cost allocation and rate design.
Okay. Thank you, Mr. Trowbridge. Would Mr. Gable be able to answer that?
He may be able to weigh into forecasts and generation.
But before I move on, just to finish it, you don't have any data between December of 2026 and any month. I mean, November, the end of the last year, November 2025, and like April 2026. Is that what you're saying?
We have our base volumes and we have our forecast test year volumes. And then I don't believe that any request has been made to analyze a difference between actuals and forecast.
Okay, thank you. Moving to your rebuttal testimony on page 7. And I want you to, are you there? And you're talking about Dr. Blank's calculation. And lines 7 through 10, you claim that Dr. Blank's recommendation changes the revenue deficiency and is a mismatch between the cost side and the revenue side. Is that correct?
That's correct.
Does Dr. Blank's recommendation actually reduce SPS's overall revenue requirement and revenue deficiency for the entire SPS system, including Texas and New Mexico? Or does it simply change the allocation of the total revenue requirement and revenue deficiency between Texas and New Mexico?
So with regard to the revenue deficiency, there is a flawed methodology that was employed, which is to assume that sales and load did not occur for the purpose of cost allocation, but that it did occur for the purpose of present revenues and the revenue deficiency. And that results in, that would result in an adjustment to that revenue deficiency if you were to look at it on an apples to apples basis of approximately 125 million. So it would increase the 47.7 million by 125 million approximately, and would get you to a target revenue deficiency of $173.1 million.
But do you agree that Dr. Blank's recommendation changes the allocation of the total revenue requirement and revenue deficiency between Texas and New Mexico? It doesn't reduce the overall revenue requirement and revenue deficiency for the entire system.
I agree that the method that he employed reduces the cost allocation to the jurisdiction, to the New Mexico jurisdiction. However, it's presented as a change in the revenue deficiency, his methodology. And so it's inappropriate. It's inappropriate to go through and reduce the cost assigned to the jurisdiction based on a base sales forecast, but include all of the forecast test year revenues in reaching the revenue deficiency. And that's really the point that I'm making there in that section.
Is it not the fact that there's significantly lower growth forecasted for Texas by SPS that causes the mismatch that you identify, that you characterize Dr. Blank's recommendation as causing?
Can you restate that question, please?
Is it not the significantly lower growth forecasted for Texas by SPS that causes what you say is a mismatch?
The mismatch is that it's not, you cannot reach a revenue deficiency where you choose base period volumes and only adjust the cost allocation, but not the revenues. If you choose, right? So we're talking about sales and load on the system, and I believe Dr. Blank's testimony suggests that base period allocation is appropriate. And he modifies the revenue requirement allocation for that purpose, but he hasn't modified the present revenues to get to the revenue deficiency. So revenue deficiency is the statistic that ultimately is presented, and sales and load, right? Again, Dr. Blank is assuming load growth will not happen for the purposes of allocating costs, but assumes it will happen for the purpose of calculating present revenues. And so it's a mismatch in terms of how you must calculate the revenue deficiency if you choose to use base period volumes.
Do you agree that SPS is assuming load growth will occur in New Mexico and will not occur in Texas?
I don't think that we are strictly assuming that load growth will not happen in Texas. I think that we anticipate greater load growth in New Mexico.
And that's based upon your load forecast. Is that correct?
It is based upon our sales forecast, yes.
And load forecasts, are they always 100% correct?
With any forecast, I think that they're subject to differences. Ultimately, it may be high or it may be low.
And do you agree that if the Texas forecasts are wrong and are too low, and the New Mexico forecasts are too high, then there will be a greater allocation of the total revenue requirement to New Mexico?
I believe that what we are doing in this case is we are presenting a picture of the costs of SPS's system. And we are also presenting our forecasts. And my understanding is that New Mexico law allows us to present a forecast test year. In that, we are presenting what we think is an appropriate picture of New Mexico, the New Mexico jurisdiction cost, allocated cost of the system, right? So that this, we are not presenting a Texas rate case. And so an assumption that these rate cases are filed at the same time, or what costs are allocated to Texas is not really, you know, in the purview of this proceeding, from my perspective.
Okay, my question was, I understand, and thank you for that answer. But my question was, if the Texas forecasts are wrong and are too low, and the New Mexico forecasts are too high, then there will be a greater allocation of the total revenue requirement to New Mexico. Isn't that correct?
Cost allocation is based on the load forecast, and it's also based on the 12 CP methodology. And that's mechanically how it works, yes.
Right. So SPS is relying on the forecasts, demand and energy in Texas and New Mexico. Is that correct?
Yes, to create its cost allocation. That's correct.
And you agree future test year cases rely on load forecasts for projecting revenue deficiencies, right?
I do.
And is the future test year provision in New Mexico required of SPS, or is it an option?
I don't know that.
Okay. Are you allowed, is SPS allowed to use future test year in Texas?
They are not. They are a historical test year state, to my understanding.
Okay. Is there a mechanism for SPS to credit back to New Mexico customers over collection if the increase in load in New Mexico is less than forecasted?
There is, there's no mechanism that I'm aware of traditionally with base rate cases to provide for surcharges or refunds. Generally speaking.
Okay. So if there's an overcollection, it would just exist. That's your understanding.
I think the concept of over collection is relative to the cost to serve. What we do in a rate case is we present the snapshot of that cost to serve. We agree on that. We agree on cost allocation. And that's the basis for the way that we go through and set rates. Base rates are not traditionally like rider mechanisms where there's a true up based on changes in costs, changes in sales, et cetera. Base rates, there are traditional regulatory lags and risks that are associated with traditional base rate regulatory rate making.
I have one more question on this topic, and then I want to move on to another topic. Is it?
You have 2 minutes, Ms. Amber, 2 minutes.
Okay. I think I need an additional 10 minutes.
An additional 10, okay?
Are you familiar with the 2585, 25-00085 case regarding the best long-term PPAs?
Yes, I am.
And the commission approved the stipulation in that proceeding?
I'm sorry, you broke up. The commission approved.
A stipulation in that proceeding.
Thank you.
Is that correct?
Yes, that's my understanding. Thank you.
And the stipulation provided that capacity costs associated with the best long-term PPAs would be recovered through base rates?
I don't have that stipulation in front of me, and I'm not. I believe so, but subject to check. So I just don't have that in front of me at this time.
Do you happen to know that whether or not the stipulation said that variable energy costs would be recovered through the fuel clause?
Could you point me to that language?
Well, it's in the 2585 case, and that would require the hearing examiners to take administrative notice of it, and I don't know if they want to. I'm simply asking you if you recall, since you were involved in that case, whether the stipulation expressly treated capacity costs and fuel-related costs differently.
I believe that the stipulation approved for the fixed capital costs to be recovered through base rates, and that the energy related settlements and benefits to be passed through the FPP-CAC, the fuel rider mechanism.
And in this case, SPS initially requested temporary recovery of capacity costs through the FPP-CAC, but has withdrawn that request as part of the settlement. Is that correct?
Yes.
And the stipulation states that SPS may recover those capacity costs request to recover those capacity costs through the FPPCAC in a future proceeding. Is that correct?
Generally, that's my understanding, yes.
Is this different than the recovery mechanism established in the 2585 stipulation?
Well, I think that the stipulation provides that the company may seek those costs, but it does not approve recovery through the fuel clause mechanism, right? So the issues of recovery, if they were brought forward through the FPPCAC, would have to be weighed. And ultimately, I think that is probably more of an issue of temporary relief that the company is seeking. It would seek recovery through base rates, but the company would have to present its case on that issue. And I'm not an attorney, and I probably shouldn't weigh into whether or not there's a contest between the settlement provisions, the stipulation, and what was approved in the settlement.
Does SPS believe that capacity costs of its long-term PPAs are within the definition of fuel and purchase power?
I haven't weighed in on that in my testimony in this case.
But you agree that they're presently recovered in base rates? Capacity costs?
Capacity costs?
Yes.
Yes, I generally agree that capacity costs are recovered through base rates currently.
I want to move on to your rebuttal, page 13, lines 2 through 4. You say that energy market arbitrage and ancillary service benefits of Cunningham Best will be directly assigned to New Mexico customers through the FPPCAC. Can you point to where in the stipulation it actually, I understand that's your testimony, but I don't see that exact language in the stipulation. I'm referring to 1 point, I believe it's 1.3 of the stipulation.
Section 1.3 of the stipulation refers to the direct assignment of the Cunningham Best, and in particular, that provision discusses the modification to the 12CP for a cost allocation between the jurisdictions. But it does not get into energy benefit and market settlement related activity.
So to be clear, it would be, in your opinion, would it be beneficial to say that what you said in your rebuttal, page 13, lines 2 through 4, that the energy market arbitrage and ancillary service benefits of the Cunningham Best will be directly assigned to New Mexico customers through the fuel clause?
So, we're bridging between two different cases here. I believe that we communicated that intent as part of the BES PPA proceeding, and I don't have that stipulation in front of me, and didn't present on this topic other than so for instance, I don't have a reference in my rebuttal testimony that points back to the discussion of the mechanics of settlement of those energy benefits. But the stipulation does not contain it today.
Regarding Plant X, do you know what Texas has decided about that that generation resource?
No, I don't.
Does the settlement in this case provide a precedent for how to treat Plant X?
It does not.
Mr. Hearing Examiner, before I pass the witness,
Yes.
I'm receiving a message that my co-counsel would like me to ask for 5 minutes to confer before passing the witness.
Okay, well, first of all, you have 1.5 minutes left, Miss Hamer. I'm stopping the clock there. Why don't we take a 5-minute recess? We'll be back here at 3:03 p.m. and you may confer with your co-counsel during that time, Miss Hamer.
Thank you very much.
Oh, go ahead. Thank you, Miss Hamer.
Reminder to everybody that you are still on YouTube and there are cameras on and microphones.
Oh, yeah. All right.
Miss Hammer, you're still live.
Thank you very much. I know that. I was trying to
I just want to make sure you weren't saying things you shouldn't otherwise say.
Thank you, Mr. Lee.
You bet.
Okay, everybody, it's 3:03, back from our 5-minute recess. Ms. Hammer, before you proceed, I just have a administrative point to address with all the parties before too much time goes on. Just make sure that everybody is back online. Okay, so earlier in the afternoon, I was able to create a new Dropbox link for the parties to upload additional or corrected exhibits. You should have all received that from our colleague Anna Kippenbrock just a few moments ago. So, for example, SPS can now upload the corrected testimony for Mr. Trowbridge so that Mr. Lee has access to it. I would just ask the parties to respect the naming convention that the hearing examiners provided for those exhibits. Also, SPS, if you can upload there the response to the bench request that was filed, I believe earlier today, that would also be helpful for Mr. Lee and the administration of our exhibits. So I just wanted to mention that again before too much time went on. Also, New Mexico Department of Justice can upload its exhibits, the direct testimony of the witnesses. And please, Department of Justice, follow the naming convention that the hearing examiners have provided. Okay, so I believe now, Ms. Amer, we're ready to proceed with your cross-examination. You have 1 minute and 24 seconds left.
Thank you. I will talk very quickly. What data does SPS have or can obtain today regarding the most current 12 CP for Texas and New Mexico?
I don't know. I'd have to check with my team.
Okay, at one point you said you couldn't do June 30th.
Excuse me, could you state that again?
At one point in your testimony, you just stated that it would not be possible to go to June 30th, and just trying to find out what date you could get the data for.
Yeah, so generally it's about 2.5 months for us to be able, before we have access to the data, and then we have to go through and we have to do the calculations. So we'd have to analyze load forecast data, et cetera. But it is not available right now. It's not something that we produce on a monthly basis.
Thank you. And what's driving the shift in allocation from Texas to New Mexico?
Generally, it's a greater increase in sales and load on the system in New Mexico versus Texas.
Thank you. I have no further questions.
Okay.
Thank you so much, Ms. Amer. Mr. Pearsall, do you have any redirect for your witness?
Yes, I do. And before I get into that, I just want to confirm that I believe SPS has already uploaded the corrected version of both. Well, the corrected version of Mr. Trowbridge's Exhibit 49 and the bench request.
That is correct. Mr. Pearsall, I have a confirmation email to that effect from 3 o'clock this afternoon.
Perfect. Okay. Mr. Trowbridge, do you recall earlier the questions Miss Amer had regarding the potential for over collections?
I do.
Yes. And are you aware that SPS annually files reports regarding its earnings with the NMPRC?
I am.
And if SPS shows on those reports that it's over earning, does the commission have any options?
It does. The commission has the ability to request the utility to come in and file an updated case.
And when Miss Amer was talking about the potential to over collect if the FTY allocators that we used are different than what actually happens, do you recall that?
I do.
Okay. And is it possible that SPS under collects if the actual sales are different than the FTY allocators that we used in this case?
Yes.
Okay.
Absolutely.
And you also recall Ms. Amer talking about if you used historical sales to drive the allocators. Is that do you recall that as well?
Yes.
And is it also possible to over earn when the jurisdictional allocators are based on historical sales?
Yes, absolutely. So just to expand on that a little bit, if we were to set based on base period sales and future test year sales outpaced was significantly higher than the base period, which is what we expect here. It's very possible that rates would be set too high because they would be set on a lower overall denominator, and that
All
could
right.
result in over collections.
I'm sorry for interrupting. Thank you, Mr. Trowbridge.
Thank you.
That's all I have here in examiner.
Thank you. Thank you, Mr. Pearsall, very much. Ms. Amer, do you have any recross based on that limited redirect?
No, Your Honor.
Thank you, Ms. Amer. Hearing examiner Gecko, I believe you had about 20 minutes, 25 minutes of questions for Mr. Trowbridge. Is that correct?
That's a rough estimate, yes.
Go ahead.
Good afternoon, Mr. Trowbridge.
Good afternoon.
Sorry, the real time is driving me crazy. One of the topics that you just discussed with staff counsel was ancillary services and value. I should just get the energy. You have a quote: the energy market arbitrage and ancillary service benefits of the Cunningham 2 BESS will be directly assigned to New Mexico customers through the fuel and purchase power cost adjustment clause. That's on page 13 of your rebuttal in support of the STIP. And you testified also to not recalling in 2585, 25-00085-UT, the specifics with respect to what occurred in that case with the idea of ancillary services and such from battery energy storage systems. And I was in that case as well. And what I recall is that there were arguments made for the benefits being provided by those battery energy storage systems being in addition to simply the capacity, and that there were ancillary benefits. And I recall I asked questions of more than one witness as to how SPS had calculated what those ancillary benefits were and how they optimized, how SPS optimized arbitrage to gain value through energy markets that would be returned to ratepayers through the fuel clause. And my recollection is that no specifics could be given by any witness that I asked those questions to in that case. Given my recollection and seeing this in your rebuttal testimony, I had prepared a question of how do you measure, how is SPS going to measure the energy, the market arbitrage and ancillary service benefits of the Cunningham 2 BESS that will be directly assigned in New Mexico?
So the Cunningham BESS is direct assigned to New Mexico. And so the plan is to be able to go through and isolate all of the costs and market value that's associated with that unit. And so, and really what that means is that the Cunningham BESS will have a pricing load node where we will be able to see the settlements with SPP for that unit. And so that will include the charging of the unit, which is obviously a cost, and then the release of that energy back into the market and the value that's paid for that energy. And that's really the bulk of, when we talk about energy arbitrage. Generally speaking, we anticipate being able to charge that off peak and then being able to dispatch that, maybe not on peak, but certainly during higher pricing periods. Also, what we see in terms of settlement at the load node is we also see ancillary benefits. So that there may be, for instance, there may be voltage control that is provided by the unit, and that would be another element of market settlement. And so all in all, that is kind of the package when we talk about kind of the energy benefits or the arbitrage benefits and ancillary services. That's that package that we anticipate being able to flow just directly back to New Mexico, because it's not a shared resource.
Thank you. On those ancillary benefits, voltage control, for example, is there a developed valuation procedure through the SPP that SPS is going to be implementing? Are the parameters for valuing those services already firmly established?
There are others. I'm just thinking that there are others at the company that could describe their process of going through and valuing that, but I think it's more of a market settlement. So if they require voltage control, then the market will facilitate some payment, for that essentially. So hopefully I'm not misstating your question, but did you ask if SPS is working on a valuation methodology, or?
Yeah, I'll ask it more simply.
Okay.
Do you have an established valuation methodology that you can go to that will be used, that that's going to be used, and how to use that valuation methodology, and it's fixed, to calculate the ancillary services benefits that you testified to as providing to New Mexico?
So the dollars that I anticipate. So for instance, I could look at a specific resource, and I could see for that resource the level of ancillary service compensation that we receive for those. But that compensation is determined by SPP in the market settlement process. And then for the purpose of estimating what that value is, I don't have estimates on that in particular, but it is relatively small. For instance, versus the potential arbitrage value.
Okay, and just to be clear, you said you could look at it. There should be other people in the company that would have that knowledge. And I asked, do you have an established process that will provide those values to SPS once this unit is providing ancillary services to New Mexico? And so it's a question of similarity, like, okay, how do I know the benefit that's going to be provided when I put the hose, the gas from the gas pump into my car? I'm going to read the screen. They're going to do it based off the volume. It's going to take my credit card, pay for it. I know how it's going to function. Do you know how it's going to function to provide these ancillary services benefits to New Mexico?
I think Witness Gable could provide more information about that. I have the ability to go through and describe how we administer settlement with the market and how that's flowed back to customers. But I do not, I don't have expertise on the valuation methodology or how that's developed.
Okay. Thank you. Did you develop that general knowledge over the last couple months?
I think part of that was preparation for the PPA case and making sure that we understood that. We also have other units like Roswell Chavez, for instance, which have been denied by Texas, or a portion of the resources have been denied by Texas. And so we have existing protocols to go through and isolate market settlements for those units.
And does that include the value gained from arbitrage?
So for the purpose of the batteries, it just represents another tranche of market settlement, right? Because there are purchases to charge the battery and then market sales to dispatch. And so there will be losses, obviously, in between those cycles. But the arbitrage value is obviously the delta between energy purchase to charge and the amount that's sold back into the market, and value of that.
And so I would imagine that if you wanted to estimate the value of that, you'd be able to look at, you do your best by looking at historical market movements and, solar gain and things of that sort. And you'd understand when that battery starts to have arbitrage value.
And I think
are you as a company calculating that? Because in a hearing in May, it was testified that information wasn't available. I was very curious about it. And if I recall correctly, and I know I asked questions about it. And so I'm wondering what process is in place for estimating this valuation, one, and two-part question. Is the procedure already in place to make sure those values are all every day at all times being recorded so that the full benefit that's being testified to can be provided moving forward?
The market settlement data energy purchased and sold is very simple. We can identify that clearly, and compensation for ancillary services. What I recollect, so I'll try to hit this in a few different points. I believe that Witness Gable will be able to talk about what arbitrage value they may have assigned to those resources as they selected those from a resource planning perspective. And I don't know that, so he will have to tell you whether or not that was included or not. And then the other point I think that was raised, as I understood it, was the complexity. There is some complexity in explaining how those resources will be dispatched in the market. So how I think that maybe some of your questions, this is what I recollect. I believe that there were questions about how do you get the timing right on when to charge the units? How do you get the timing right, to optimize on dispatch of those units? And so there's complexity that our folks that are in operations have the ability to get into greater detail on. I don't have a reference in this case.
Okay. And so I appreciate that. And to make the question really simple, as a regular process, or is it being taken into account now on a regular basis, estimations of arbitrage value when you look at the financial situation of the company?
What I would say is that arbitrage value, because it is that arbitrage value is all flowing through the fuel clause, and there are no profit incentives associated with the fuel clause. So it is market settlement that occurs, and then that results in an allocation of cost to the jurisdictions. And so for New Mexico, in the FPPCAC, as we see these battery units come on, or as we see a direct assigned, the Cunningham BESS assigned, what we'll be able to do is we'll be able to go through, isolate the settlements associated with that unit, and then that will flow through the FPPCAC clause, direct back to customers.
And so is that, the question was whether, as a company, you're estimating the value that is that is coming to SPS, or could possibly come to SPS through arbitrage. And I think I understand the process. I'm just wondering, the question is whether you're taking that into account in your planning, whether you're regularly estimating those values. Because I ask this question because it's starting to appear a lot in cases, and yet no details being provided with it. And so perhaps it's that there still isn't knowledge, and we have to look at what these sales are going to be over the next year. Or it could be that it isn't being done, even though the information's there. I don't know. I'm trying to understand.
I'm not aware of that process, and I'm not aware of that information or forecast. But Witness Gable could speak to that from a planning perspective, which would include, has the potential to include that arbitrage value in their resource selection. Is probably the best that I can do right now.
Okay, thank you. And then you said there's no incentive because it's just passed through the fuel clause, but are you familiar with testimony in this case where SPS asserted that they wanted a 10% of off-system sales as an incentive to maximize profits to the company that could be done through energy market sales?
Yes.
Okay. So SPS's position was that there is an incentive, if that money is there, but that it was stipulated to that SPS should maintain that incentive simply in the interest of providing the service that they're supposed to provide to ratepayers. That's how I understand the result in this stipulation. Would you agree?
That's not something that I've testified on in this case.
All right, thank you. Okay. I'm going to turn to production tax credits, and these are some questions that I asked recently to Mr. Hurt, I believe. I'm trying to keep myself straight here. And what I was trying to, did you hear my questioning with Mr. Hurt earlier today?
I did.
So do you recall my attempt to just kind of understand the relationship between allocation of costs through rates and the allocation that PTCs will be allocated on an energy basis, and my trying to get to understand what that means to be allocated on an energy basis?
Yeah, so I can try and talk you through that, and then I may be able to show you how that works exactly.
Yeah, that'd be great. Mr. Hurt referenced that you might have had a table or something of that sort.
Yeah, let's see if I can share my screen here, and let me know if you can see that.
I can see it. Thank you.
Okay, so this particular attachment is AGT BR3-8. And so this is one of my attachments to bench request number 3. And this 8th attachment represents my work papers. And so fairly large number of tabs, but ultimately this helps me to go through and work through rate design, bill impacts, etc. And so one of the things that we look at, right, so as I'm preparing the bill impacts for this case, we have PTCs that are going to be flowed back through the fuel clause. And so I need to go through and I need to come up with what is the value associated with those PTCs from a bill impact perspective. What this does is, for the purpose of bill impacts, what I've done is I have looked at the essentially, right, in our case, it's our forecasted energy allocator. And so what we know is when we go through and we look at all kWh sales at meter, that, for instance, the residential class represents about 5% of total kWh sales from a forecast perspective. So I'm going to walk you through the bill impact, and then I'm going to cut back over to how this mechanically works in the FPPCAC. Yeah, go ahead.
Can I pause you just for 1 second? Maybe it's not important, but you said forecasted energy allocator. Mr. Hurt was referring to energy at source. Is that the same allocator? You guys using different language for the same one?
It is. It's the same. So when we allocate energy, typically what we're doing. So let's do this. Let's go to the FPPCAC. The FPPCAC is updated on a monthly basis, and the allocation of costs are updated on a monthly basis. So we'll look at total KWH sales of all SPS. We will determine the amount that supports New Mexico or Texas, and wholesale's rolling off, but the portion that's Texas and New Mexico. And then from there, there's a further breakdown into the voltage classes. So we only have 4 rates that are established. So all customers that are on the secondary voltage class will pay the secondary voltage fuel rate. We don't have different rates for each customer class. It's just it's a single rate for the secondary system, for the primary system, 69 kV, and then 115 plus. Those are our 4 voltage or fuel rates that we charge customers. So for the purpose of energy allocation, right, what we would do is we would look at the actual PTCs that were created. Then we would look at the allocation of sales to a voltage class, and then they would receive that credit on that basis.
And when you say sales to voltage class, what is sales? Is that a dollar figure? Is that a kilowatt hours? What is that? What is sales in what you just said?
It's KWH.
It's KWH.
Yep.
So the PTCs are going to get allocated according to the KWH that are used by the 4 voltage classes.
Exactly. A loss adjusted. So, right, if we take this all the way through, we start with sales. They are loss adjusted to get us to a common denominator for allocation. And then we apply credits on that basis.
Okay. So if I'm looking at your screen here, yeah, you were yeah, you're in a good spot.
I'm sorry, Jez, I can barely hear you.
I'm sorry. I said, no, it's fine. You were in a good spot. And so looking at the screen, the shared screen, I see 15.58 billion kilowatt hours of New Mexico retail sales. Which of these 4 classes, what's contained in primary voltage? What's a typical customer? If you had to tell me rate classes that are also primary voltage class for the purpose of FPP-CAC.
Primary general.
Primary general. And 69 kV voltage, which rate classes fit into that one?
LGST 69 to 115 kV.
And 115 kV, LGST, and maybe another rate class.
And that's it. So LGST is just going to be the 115 kV plus category.
So between those 3, we're going to get 5.17 billion. Add the 127, we're going to get 5.34. We're going to be at a little over 13 billion out of the 15 billion. So if we divide 13 by 15, that's the percentage of production tax credits that are going to go to those rate classes.
And so this schedule in particular,
is that correct? What I just that math I just did?
Yes, that's correct.
Okay. This is wonderful. I've been asking questions for 2 days, so thank you.
So when you look at this facility in particular, we believe we have 12.25 $12.3 million in PTCs that will be credited back, and you can see exactly the voltage class allocation of that.
Very helpful. Okay, thank you. I think I'll look at what my other questions are. Luckily there's some folks that assist the commission as advisors too that can help me then take that information and answer some more questions. So thank you. Appreciate it. I think you're still sharing your screen, or am I wrong? Oh, it's because I moved my screen. Sorry about that. I moved it to my big screen to be able to see that well. Just stay here. Okay, let me see what else. Where's that? I'm just reading through, many things that I developed have already been covered. I'm almost there. Here, I have a couple questions about the demand ratchet, which you testify to, and I didn't write direct, but I believe it's your direct testimony at page 16, line 15. Let me see. Are you there before me? Because I could tell you what I'm seeing in my notes.
16 of my direct.
Yeah.
Okay, I'm there.
And I marked down line 15 and then over to page 17 that, you testified that this is with respect to whether a little bit of a debate in some of the testimony over whether the demand ratchet should be phased in over an 11-month period because it's a procedure that looks back over 11 months. And so concerns were spoken about of, customers being subjected to rates that are based upon behavior that was taken prior to having knowledge that that behavior would ultimately affect a rate through the demand ratchet that is based upon that prior behavior. And just to ask it clearly, if it's implemented how it is now, am I understanding correctly that customers will have to manage their electrical use now in a manner that takes into account rates that are implemented based upon or their activity when they didn't know there would be a rate effect based upon that activity? Is that a correct understanding?
Well, I can give you my perspective on it. So first, the stipulation approves the ratchet without delay. So that is a majority of our parties, and it's also the parties that would be affected by that. And so because that ratchet that ratchet, so you know, is for PG and our LGST classes as well. Part of the reason for the ratchet, either increasing the ratchet or establishing the ratchet for PG customers, is that there is inter-class subsidization that exists. And let me explain why it exists. So we may have a customer, and let's just say, for instance, that oh, okay.
Can I clarify one thing? Inter-class or intra-class?
It is intra-class. So it is
That's
between customers within a class. And
Thank
what
you.
we're trying to do is we're trying to improve intra-class equity between customers and how they use the system resources. I mean, to shorten it, right? If we looked at an example, we would say, hey, we've got one customer that is uses 1 megawatt 12 months out of the year. They use 1 megawatt. They always use 1 megawatt. We plan our system to go through and ensure that they're paying for their 1 megawatt. We have another customer that uses 1 megawatt, and they happen to use it for 11 months out of the year, and then they have a reduction out of 1 month. From a cost causation perspective, we really are providing. We also need to plan for 1 month for that customer, or excuse me, 1 megawatt for that customer as well. What the ratchet does is it limits the amount that your bill, basically your bill demand, will go down as a result of a reduction within an 11-month period. So we look back, we establish that, and then implement it that way. And so the higher the ratchet that is, the less subsidization we have. Ratchets, what a ratchet does is it increases the billing determinants. So before, right, there was no, let's just say that went from half a megawatt down to half a megawatt. For like our PG customers, for instance, there was no recognition at all of the fact that this load was dropping. And so that has to be subsidized by the rest of the customer pool in the rates. When you put that ratchet in, you've got a higher number of billing determinants. It lowers overall rates for all customers. And that's really the product of the ratchet. My recommendation in my rebuttal, I present that I think that we have sophisticated customers. They understand these risks, and this is really implementing immediately. Helps us to address that intra-class subsidization that I think is happening now.
I appreciate the explanation. It solidifies, and you've hit on all the points that I was thinking about. You would understand if a hearing examiner was interested in something that feels a little bit retroactive, and how that would lead to questions, I imagine.
Yeah.
So thank you for that. Let me just go through my last little bit here and see if I have any more questions. So I have one, and it's because it got raised earlier too. So this is either your testimony in support of the STIP or rebuttal at page 20. And it's the stipulation adopts the 1PCP system load factor for the AED 4CP methodology as part of the overall negotiated resolution. We've seen testimony how that's widely accepted, commonly employed. Mr. Hurt testified that, in the application for this case, it was just status quo, why the AED 4CP was used. And Mr. Hurt also testified to that, if I recall, we could go back and look. I'm not going to say that. I don't need to speculate. So here you said, so there were questions to Mr. Hurt of kind of like what the reason is for this, and what the reason is for the move to the 1CP, and the answers kind of got stopped at the level of, well, that's what we stipulated to. That used to be the status quo. Okay, yeah, that does seem to affect a shift with respect to large load customers. And you have a quote here that says, by calculating the system load factor based on the single highest monthly peak rather than a multi-month average, the 1CP method provides a more direct and focused measure of the relationship between a customer class's average demand and the system's peak condition. Is the direct and more focused part because you've isolated one single peak? Is that what you mean by it's more direct and focused, as opposed to having 4 peaks? Or, generally, what are you saying there?
So when we talk about peak allocation, if we think about the resources that we go through and procure for customer classes, we know things like residential customers have a low load factor. That is the average amount of energy versus the total peak to serve them represents there's a delta, and residential rates, for instance, are higher because of that. It isn't about throughput. It's about the allocation of those resources to the class. What do we need to serve them, if even on a standalone basis? And so I would just say in traditional cost allocation, the 1CP method in an AED 4CP is more common, and that's presented in the NARUC manual. Part of the reason
I'm sorry, presented in the NARUC manual?
Yeah, in the NARUC manual.
Thank you. Go ahead.
Okay. The reason that it's more direct and focused is that we are looking at the 1CP peak. So we would be looking at the summer period that the system peaks, and then we would be analyzing the, for instance, residential classes portion of that peak. So as opposed to looking at what might be diluted around that single summer peak, the 1CP gives a true measure of excess, which is capacity required above average usage. Average usage is just, all kWh sales divided by 8760, which are the total hours. That would give you average. And then above that is the single peak. To really understand, right? And the single peak, we still have a summer peaking utility at this point. And so that single peak is what we must meet.
And if you know, traditionally that single peak is driven by like air conditioning load and such in the summer from a residential class perspective, is my understanding. Is that a fair understanding?
That's my understanding generally, yes.
And a large load or, you know, more firm load customer, they don't have that peak because their electricity usage isn't being driven mainly.
I'm sorry, Judge, I can barely hear you. Their
I'm
electricity.
sorry. I'm very sorry. I'm sorry, Mr. Lee. I need to. I'm sorry. I'll fix that. With a large load customer, the amount of electricity usage isn't so affected by summer electricity to create that summer peak. You know, there's a steadier load over the course of the year due to what that electricity is being used for, is my understanding. Is that a fair generalization?
Yes.
So if we go to the highest single peak, as opposed to having 4 peaks, 3 of which would be lower than the single peak, it's getting more focused on something that will isolate a moment in which the smaller customers, small businesses and such, have a greater percentage share of that peak than they would if we took a peak moment in the month of January, for example. Is that fair?
Definitely. If
So-
I was following your
Yeah, said simply that if we, you know, if we calculate based on one peak that's higher than an average of 4 peaks, and that one peak is highly representative of electricity usage by smaller customers, it's going to affect those customers to a good degree. And so what that says to me is it helps me just understand that a little bit of testimony that I heard earlier of this results in some way a shift in costs that will be allocated to classes that are relatively more responsible for that single peak on the system. Is that fair?
I don't know that I may not be following that example. But I think that I can present something that may be helpful. So just to put this into may I share attachment AGT BR 3-3, which is the bench request 3, and it's my third attachment.
Please do.
Okay. All right, and let me know if you can see that.
I can.
Okay, so here in column E, this represents the $90 million allocated to the classes based on our traditional methods. So it includes, right, and a primary driver of that is our AED 4CP calculation. And here what we see for residential service is we see an allocated base rate increase of $43 million in the case. Within that number, 2.3 million of that is as a result of moving from a 4CP method to a 1CP method. So that number is higher by 2.3 million as a result of that. And I have an attachment to my rebuttal that provides all of the classes and the delta that 1CP versus 4CP causes. But the most significant is up in the residential class. When we look at the adjusted increase in rates for residential, what we see is it's not It's not 43 million based on cost causality. It's 14.5. 2/3 of that increase is being subsidized through the gradualism adjustment. So
I'm sorry, through that what adjustment?
The gradualism adjustment.
Thank you. You're trailing off just a bit.
Okay, sorry, I think it's because I'm turning a bit. Thank you. The reason that I mention this is just to put into perspective what that adjustment means and how much it impacts residential customers. And I would just say in this case, right, that $2.3 million increase in the methodology is by far offset by the gradualism support of $28.5 million.
Thank you. And given that, I should wait. If you have something important to help my understanding further, I'll save it.
Yeah, just one. I was just going to say, secondarily, this change to the 1CP was what was agreed to in the stipulation. But we also have agreed to stakeholder engagement on class cost allocation. And so we will continue to develop that through presentation and discourse with interested parties.
Thank you. So my question is kind of the same one then ultimately. This is super helpful again, so thank you. But if the shifts aren't that large, which is a point that you've just made, and beyond it being more common in the industry, because the other thing to put together is there must be, there was a reason at some point where SPS adopted a methodology that under current standards is not the most common, and that would have been done for a reason. Why the change? Like, what motivates a stipulation to change this? And I'm not asking for what was said behind closed doors, but generally, what motivates a move? Because it's not universal. There's still other utilities using that 4CP. And so what's the motivation? I mean, if it's pennies, I might as well just leave it like it was.
Well, I think I mean, I can't weigh in on the motivations. I can say that Dr. Blank of staff in his direct testimony, the question was asked, should SPS change its class cost allocation methodology? And paraphrasing, but he said, no, not in this case, but in the next case, they should consider shifting to a 1CP. From my perspective, right, it is when we look at cost allocation, cost causality, there's reason to use a more pure method, right, which is this issue that we've kind of talked about. And
there's my curiosity.
Yeah.
Why is it better to have a more pure method? Like, a lot of times, like, I would want to make a decision on something based upon an average so that I didn't make decisions based on a single instance. Like, I burned the pizza when, you get the idea. I'm gonna want to set my behavior up based on an average if I have to choose just one way. And why is it better if it's pure? And that's where I originally started this question of direct and more focused. And that's the piece I don't understand and would love to understand.
Well, and I think we'll have the opportunity to debate that. What is an appropriate class cost allocation, right? So traditional systems were based on dispatchable resources, so it truly was a procurement for the peak. Now our resource mix includes variable resources like wind and solar. Wind is producing during different periods, typically than peak. So I think that the stakeholder engagement will allow us to at least consider, changes in our resource mix, intermittent resources, and battery resources as well.
And also consider changes in your customers' load profiles, average and singularly, I would imagine. Well, it's not just about resources, it's about the load profiles of the customers on your system as well, correct?
Yes.
Okay. Okay, thank you again for that. And that is the extent of my questions. As always, I appreciate it, Mr. Trowbridge. Thank you very much.
Okay, thank you very much.
Thank you, Mr. Trowbridge. Mr. Pearsall, do you have any follow-up questions for your witness?
No, I do not, Your Honor.
Thank you, Mr. Pearsall. Well, given that there's no other party waiting to cross-examine the witness and the council has no... Okay, yes, Miss Amer. Go ahead, Miss Amer.
Sorry, but I just had one follow-up question from something that hearing examiner Getco asked, which is for Mr. Trowbridge. Can I ask?
Okay, one question, Miss Amer. Go ahead. One question.
Mr. Trowbridge, which class benefits the most from a 1CP change?
I can go to one of my attachments if you give me a second.
Can I supplement that question to be both on a dollar basis and a percentage basis? And
Okay, here's what we're going to do. We're going to take a 10-minute recess. I think Mr. Lee has gone very long and been very persevering in his efforts. So we're going to take a 10-minute recess. And Mr. Trowbridge, when we come back, you can answer that question that Ms. Amer and Mr. Hearing Examiner Getco just posed to you. So we're in recess until 4:15. And then we will proceed with SPS's next witness. See you all back here at 4:15.
Hi, so I have a little break.
Oh, okay, cool. You have like.
hey, Judy, you're on.
You're on, Mike.
You're on. Your mic is on again.
Darn.
Okay, everybody, thank you. Good afternoon. It is 4:15. We are back on the record. And I wanted to just do also a little bit of housekeeping before we close out the day. It looks like we may be able to get to one, maybe even two witnesses from SPS after Mr. Trowbridge answers this final question. So we'll just try to continue to proceed efficiently, and we'll head towards the 5 o'clock hour in that fashion. Okay, Mr. Trowbridge, I believe you were set to answer the question from Ms. Amer and Mr. Getko.
Okay, so in attachment AGT stip R2 to my rebuttal testimony, I have an attachment on the difference tab. It states the relative dollar difference that is associated with the shift from a 4 CP method to a 1 CP method. And the two classes that you see a reduction in major or significant reduction in cost to are, of course, our highest load factor customers, primary, general, and 115. But the question was, so that's the mechanical answer. But then what I wanted to do is I wanted to be able to present back on this table, which is that I don't know that without that agreement that the parties would have stipulated to this level of gradualism. So when we talk about the cost to customers, who benefits, cost to customers or different classes, I think that it's important to keep that in perspective as well.
Thank you, Mr. Trowbridge. Mr. Pearsall, any final questions, redirect?
No, Your Honor.
Thank you. Thank you, Mr. Pearsall. Mr. Trowbridge, once again, on behalf of all of us here, thank you for your professionalism and your willingness to participate in our proceeding. You may be excused.
Thank you. My pleasure.
Okay, so who is the next witness for SPS?
The next witness for SPS is Megan Scheller.
Judge, can that document be taken down?
Exactly.
Yes, we can make sure that happens. Give me 1 second. They're in a different room, so I'm passing the word along to make sure that they pull that down while we get Ms. Scheller to the
I just
stand.
removed it.
Oh,
I just
perfect.
removed it with my host, abilities. Okay, Mr. Pearsall, we're waiting for Ms. Scheller. Is that correct?
Well, she is there now.
Oh, is she? Okay, I didn't see her. Hi, Ms. Scheller. Good afternoon.
Good afternoon.
The court reporter, Mr. Lee, will swear you in. Just give him a moment to make his final preparations.
Ms. Scheller, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending shall be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, ma'am. Go ahead, please.
Thank you. Ms. Scheller, can you state your full name for the record?
Yes, my name is Megan Nicole Scheller.
Thank you. And can you state your position and your employer?
I work for Excel Energy, and my position is Area Vice President of Technology Business Operations, PMO, and Product Governance.
And can you confirm that you prepared what's been marked as SPS Exhibit 18, which is your direct testimony in this case?
I did.
Thank you. And Ms. Scheller, your exhibit has already been pre-admitted into the record. So with that, SPS will tender Ms. Scheller for cross-examination.
Thank you, Mr. Pearsall. I believe that staff had requested 10 minutes of cross-examination for Ms. Scheller. Is that still the case?
No, Your Honor, we do not have any cross-examination for Ms. Scheller.
Thank you, Ms. Amer. So with that being the case, I would maybe just check, just for everybody's situational awareness, the chairman has rejoined us, and obviously he is able to ask questions of any witness at any time. But in the meantime, I believe Mr. Hearing Examiner Gecko may have some questions for this witness. Is that the case?
I have one base question, and it might generate a follow-up or two. Yes.
Go ahead.
Good afternoon, Ms. Scheller.
Good afternoon.
Can I point you to page 5 of your direct testimony, line 8?
Yes.
And you go over the numbers there for SPS is requesting to include $106,688,109 in New Mexico rate base for technology services and ESS-physical security capital additions. And then he said, the vast majority of the technology services capital projects I address are projects that are implemented across Xcel Energy and affect all of the operating companies. I couldn't locate where the calculations are for allocation to SPS as opposed to the other companies that are underneath the Xcel umbrella. Is that in your testimony?
It is
somewhere?
not.
It is not.
Yeah, and for technology investments, we use an enterprise allocator out to the jurisdictions. That would be handled in a different testimony.
And so who would handle that? Do you know?
I don't know if I would put that back to, I don't know. I don't know if that's Zoe or if that's back to Ms. Johnson.
Okay. Maybe, and Hearing Examiner Schaefer, you can correct me if this would be inappropriate, of that perhaps counsel for SPS could see who that witness might be and let us know. It could even be that, a first look would be for me just to look at that testimony once I understand where it's at and maybe avoid having to call somebody back. But that's what I'm interested in understanding, how that's done, what the bases are for that allocation.
I can do that, Your Honor. If you give us 1 second, I could confirm. I don't want to misspeak because I believe that is Allison Johnson, but I just want to confirm.
Okay.
Okay, so I have confirmed that is SPS witness Nicole Doyle.
Okay. Okay, thank you. I think that's a procedural matter that maybe we should dismiss the witness first, and then we can talk about where Ms. Doyle might enter in, because my quick look at my list is that we hadn't as yet addressed testimony by Ms. Doyle, and maybe we address that in the morning, even after I've had a chance to look at that testimony and determine if I even have any more questions. So I guess I just handled the procedural part of it. So that is the extent of my questions, Ms. Scheller, and I appreciate it. Thank you.
Thank you.
Okay, so no cross-exam, no redirect. Mr. Pearsall, I just offer the floor to you if you have any final questions for Ms. Scheller before we dismiss the witness.
No, I have none.
Thank you. Thank you, Ms. Scheller. You may be excused.
Thank you.
Okay, so we're getting close to the 5 o'clock hour. Maybe we can just go ahead and call SPS next witness and get started on that with the few moments that we have remaining in our day today.
Thank you, Mr. Examiner. And SPS's next witness is Naomi Koch, and I'm working to get her on the Zoom. I don't think she expected Ms. Scheller to finish so quickly, but we're working on that.
Thank you.
You can just give us a moment.
I see the witness,
Hi.
Judge.
Ms. Koch, can you hear me?
Yes, I can.
Hi, thank you for being with us today. We'll just go ahead and get started with your testimony and then carry it over to tomorrow if needed. The hearing or the court reporter will swear you in once he gets situated.
Ms. Koch, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. Go ahead, please.
Thank you. Ms. Koch, can you please state your full name for the record?
Naomi Koch,
By whom are you employed and in what capacity?
Excel Energy Services as the Director of Tax Reporting.
And have you adopted as your direct testimony SPS Exhibit 232, apologies, which was initially filed by Ms. Laura Brennan?
Yes.
And since that exhibit has already been admitted into evidence, I have no further questions for Ms. Koch. She's available for examination.
Thank you. Thank you, Ms. Hardy. Staff, I don't believe that you had requested any time for the cross-examination of Ms. Koch. Is that correct?
No, Your Honor, we did not reserve any time for cross-examination of Ms. Koch.
Thank you. Hearing examiner Gecko, do you have any questions for the witness?
Yeah, I have a number. I'm sorry. Miss Amer, were you attempting to say something more? I think your voice came through.
No,
Okay.
I'm sorry.
Yeah, thank you. Yes, I have some questions, and I believe the majority were from questions I had asked previously. So I'm going to begin. Hello, Miss. Is it Coke or Cook? I had a friend named Aaron Cook.
Yeah, it's Coke.
Coke. Okay.
Yep.
Thank you. So I want to talk a little bit about production tax credits. And I'm playing a little catch up with my notes from asking questions to others. Let me make sure I have the right thing on the screen. Computer. There we go. Stipulation. Okay, in the stipulation, provision 1.8A on page 7 establishes that SPS may earn a return at the cost of long-term debt through its FPP-CAC on its deferred tax asset associated with production tax credits created by Plant X Solar, Cunningham 1 Solar, and Cunningham 2 Solar, to the extent those PTCs are unused or not yet transferred. And when I was speaking with other witnesses, I asked the question of, I referred back to a final order in a case that was before this commission, case number 23-00252-UT. And part of the text in that order said that SPS disagrees that it would not have incentive to sell the tax credits and instead allow them to accrue carrying costs in the DTA. And it cites to SPS's exceptions in this case, and those exceptions said that SPS has every incentive to recoup the dollars already advanced to customers by selling the tax credits on the transfer market, even if it is unable to do so at 100 cents on the dollar. Could you explain the incentives that SPS has to sell those on the transfer market, given a stipulation that allows SPS to earn a long-term debt carrying cost on that deferred tax asset that's in the stipulation?
Yes, definitely. I think a little bit of context. I was listening to several of the questions from yesterday, and I think a little bit of context might help explain. So PTCs or ITCs can be monetized in one of three ways. They can be used in the current year to offset like our current year liability. They can be carried forward to be used against a future liability, and technically carried back, but SPS does not have that option just based on its facts. And then they also can sell the credit, which has kind of been a hot topic, obviously from your questions. So starting with the first, whether SPS can use it against its current liability. SPS right now, if in the stipulation cost of service, what I saw is that there is a small taxable income, but it was very small, and yet SPS still has a carry forward of the pre-IRA Sagamore and Hale credits. So it's still using those. So for SPS, using them against its current liability is not, it just can't. It doesn't have the appetite to use the credits. So the second choice is to carry the credits as a deferred tax asset to be used against a future tax liability. But similarly, SPS does not have the appetite to, it's still using the old Sagamore and Hale credits. So it does not have appetite to use the new credits from Plant X, Cunningham, even for that matter, current year, Sagamore and Hale. So the next option, the next choice is to sell. And to be clear, we could maintain a deferred tax asset on these credits, both the current Sagamore and Hale credits, as well as Cunningham, Plant X, et cetera. However, the transfer costs are lower than the carrying cost of that DTA. So it's beneficial to the customer if we sell the credits.
Transfer costs are lower than the carrying costs. So, and finish your sentence again, I'm sorry.
No, that is it. I mean, just that because the transfer costs are lower than the carrying cost of the DTA, the deferred tax asset, sorry. It is beneficial for customers, for SPS to sell the credits to keep the customer costs low.
Yeah, and I asked a question yesterday where to another witness where maybe it was right at the start of today, as to the decision-making process and to what degree that took into account the effect on ratepayers. And without going back and looking, subject to check, I thought the answer was that Excel, I should be speaking of Excel because these taxes are handled across from various subsidiaries. The tax decisions are made at the Excel holding company level, correct?
Yes, I mean, the sales are managed by Xcel Energy Services employees, and yes, that decision is made there, but the benefit.
Sorry, the sales are managed, I'm sorry, the sales are managed by?
Xcel Energy Services, like we're service company employees, if that's literally what you mean. But I would say the benefit applies to SPS customers, like for SPS on a standalone as well.
Right. Okay, I gotta be careful. I guess going on two paths now. I'm gonna finish this little side path real quick. But defer a production tax credit that's earned by SPS, does Xcel Energy have the ability to use that production tax credit against tax liabilities that it has for other subsidiaries in the Xcel system in certain circumstances, in any circumstance?
You're correct that the tax credits are used by the Xcel Energy Group. That's kind of how the tax return works. However, based on our longstanding rate making principle, it is evaluated on a separate company basis. And it's not the decision. I mean, it's not like we can sell the credit, I don't know, hypothetically on a separate company. We do have to make the decision at an Xcel Energy level. But I would expect that if they ever contradicted each other, we would have to dig in and really make discuss the decision and evaluate it more. However, for now, it is beneficial to both Xcel Energy, but absolutely also to SPS.
Okay, that's interesting because the decision of what to do with the tax credit is then made from the perspective of Xcel, and but the benefit immediately when a production tax credit is earned is applied to SPS as ratepayers. So that's an SPS benefit, but the decision making of then what to do with the DTA is really a decision made in consideration of, at least in part, the totality of Xcel. Is that fair?
I don't agree with that.
Okay.
I'll repeat what I said, that I think the decision is made, yes, at Xcel Energy level, but it is also absolutely beneficial for SPS to sell these credits. And if there was ever a disconnect between Xcel Energy and SPS, we would have to re-examine whether we sell. But as I mentioned a few minutes ago, with SPS's current kind of taxable income and its backlog of credits, if you will, it is absolutely beneficial for SPS to sell these rather than have the carrying charge on the deferred tax asset.
And thank you for that. And that goes back to the line of question where we started. And I wrote down transfer costs are lower than the carrying costs, and therefore it's beneficial for SPS Xcel to transfer those production tax credits because the DTA, because it benefits ratepayers. And then I started referring to testimony where I understood that I heard that the decision is made with respect to the financial perspective of SPS. And so is your testimony different, that the decision is made factoring in? Well, first I'll just say, is the decision made purely upon a consideration of what would be most beneficial to the ratepayers?
I think, well, no, I'm trying to think. I'm not sure what that would mean. It's better for customers, and Xcel Energy, SPS specifically, it's better for the company, for SPS, to get cash in the door faster. And so by transferring them, we're monetizing them quickly. And that benefits, yes, SPS, Xcel Energy, but as a result, that also benefits customers too. I mean, SPS needs to have a strong, cash, and we want to keep, excuse me, our borrowing costs low. So that is beneficial to customers. I can't say that there isn't a benefit to Xcel Energy, but that's not why we're doing this. It's really to keep the costs low for customers.
Okay. And so with the Hale and Sagamore, you referred to, prior to the Inflation Reduction Act, you accrued those, and is my understanding correct that prior to the passage of the Inflation Reduction Act, that if you couldn't use option 1 or use option 2 in combination with option 1, which would be to carry it forward and use it on a tax liability in a subsequent year, you didn't have the option to sell it in a transfer market. Is that correct?
Correct. The Inflation Reduction Act was enacted in 2022, and that allows us to sell credits that kind of introduce transferability. And we are able to sell any credits generated after 2022. So anything, even if the wind farm or the project existed before 2023, that's okay, but we can't sell those related credits until they were earned after 2022.
So the credits that you still have that you referred to from Hale and Sagamore were earned prior to 2022, and since they were earned there, even though the IRA came into effect, the prior law still applies to those credits. So you'll never be able to sell those credits in a transfer market, the ones that you earned prior to 2022. Is that a correct understanding?
Yes, except to clarify that I hate using these straddled years. They apply, you can sell things post 22, so we can't sell pre 23, just to clarify. So.
Can you say that again? I'm sorry.
So, yeah, sorry, I'm straddling years. So you can sell tax credits generated after 2022. That means you cannot sell credits generated before 2023. So just a point of clarification to kind of clarify what you said.
What about tax credits that were earned in 2022?
No, you cannot. Those cannot be sold.
Okay. Thank you. Yeah. So is there a relationship there between the new tax credits that are being earned 2023 and later and the ones that were earned 2022 and before? That I think you can quickly explain to me why you're prioritizing applying those older production tax credits and not the new ones to tax liabilities.
Are you asking why we're selling the 23 and later, or?
Well, yeah, you referred to that you still have Helen Sagamore from 2022 and before, and I mean,
Correct.
that's obvious. And so maybe this is the better question is, are you selling all the production tax credits that you received 2023 and later? Have you sold all 2020, any production tax credit that you received 2023 or later?
Yes, we are.
Have you sold all production tax credits that were received in 2023
Yes.
and 2024
Yes.
and 2025?
I believe so, yes. I think we're either, I'm not sure if we've monetized them all officially, but we've contracted to sell them.
Okay. So then my question just about the stipulation was, well, could that ever change? Could the markets ever change?
Yeah. So I would say the market, even though this is only our 4th year of selling, the market is kind of getting busier. There's more PTCs, ITCs, whatever on the market. So that does put pressure on the market for us to, keep for our discount, our transfer discount. It does challenge it, but we continue to negotiate and push for low transfer discounts.
So given that uncertainty and of what the future market is, my concern has been that I don't see in the stipulation protection from a situation that might occur where it becomes infeasible to sell the production tax credits efficiently. And therefore, you're forced into a situation where a deferred tax asset of these production tax credits is still on the books of SPS or Excel, however that's done. And there's a long-term debt on there. And by the math I did at 5.29%, I used an example of $162 million. And my math said that in 10 years, there'd be $85 million in carrying costs. And that's what was concerning to me of my ability to hypothesize that situation. Can you speak to that concern that I'm feeling?
So I think there's 2 parts. One, there is a cap. But we are going to continue to pursue the transfers. But we are stipulating to the 10% for the cap on the transfer costs. But second, if we did have to carry the deferred tax asset, keep in mind that the customers have already gotten the reduction to their bill as part of the FPPCAC. So they got that kind of pretty close to immediate. I mean, they get it shortly after the credit is earned. But then it does take a minute for us to either sell or utilize it in the tax return. And that's where the transfer cost or the carrying charge come in. But again, the customer got the reduction to their bill pretty quick. So the carrying charge on it, though, we are going to be, I don't know if the fighting is not the right word, but pushing hard and negotiating hard to keep that transfer discount low because we don't want the customer to have to incur the carrying charge.
Well, and those are 2 issues. We've got the transfer cost issue, and we got the carrying cost issue. So let's just focus on the carrying cost issue for a moment, if we may. And yeah, the customers receive the production tax credits pretty immediately because it's rewarded for the energy that they're paying for. And they're also charged those carrying costs pretty immediately because those go through the FPPCAC, correct?
That part I'm less familiar with, frankly, between the various iterations of our credits, but so I can't confirm that. I apologize.
And so why wouldn't, the decisions have been made, and I wasn't in all these cases, but the decisions are made with respect to resources and what the value is of those resources, a cost benefit analysis, taking into account probabilities of production tax credits being earned and those not being reduced in overall lifetime value to the ratepayers due to carrying costs. And why would there not be some kind of provision that shares that risk? We're at a situation where what's occurred is the production tax credit has been issued. There's been a benefit to the ratepayers, and now every day that there's carrying costs on a DTA, that eats away a little bit at what that benefit was. But other than are there measures there to share that risk? Why would something like that not be included to protect ratepayers against that unknown risk? We don't know what the markets are doing.
What do you mean by markets?
The transfer markets that are becoming saturated with production tax credits, or have a higher amount in them and force you to work harder to be able to achieve sales.
So I'll answer the last part. I think it goes back to, like, we do have protection though, right? Because the caps are referenced in the stipulation.
Let's just pause there again then, because maybe I'm not understanding something. My understanding is that there's a cap on transfer costs of 10%. And my understanding is that transfer costs are a cost that's completely separate from carrying costs. Like, I could incur a carrying cost for 6 years, and then I sell it, and I'm charged an 8% on what that DTA is. And so I don't see how the 10% transfer cost cap addresses my concern about carrying costs.
I think I misunderstood your question, because you ended the last question, I think, referring to the markets, and you said that was the transfer markets. So I apologize. I thought that's what I thought you were including both. Okay. As far as I am not aware of something that would be a protection for carrying charges. I'm not familiar with that. I don't know if something like that exists. Elsewhere, I don't know. That might be more of a policy question. I just don't know.
Right. Like, I imagine something like, I think what I said in previous was, a date by which sale should be achieved. If sale can't be achieved by such and such a date, then there would be an obligation to report upon why there's an inability to sell. There could be an option of, a certain period in which the entirety of the carrying costs are applied to ratepayers, but after a certain date, given that there's an unknown risk with respect to these, the company could come to the table with a sharing of that risk, so that carrying costs that are accrued after a 3-year period, that'd be a shared cost that would be split between ratepayers and the company in some measure.
If I may, there is a limit on how long you can't transfer credits forever. You have until the return is filed. So for us, it's roughly September or October the following year. So it's not forever. We can't make a decision in 5 years to go back and transfer something. We need to make that decision and effectuate it by the time our return is filed, which again, we generally file in the fall of the following year. And I will reiterate, I think I understand your question. However, I will reiterate that the customer did get the benefit up front. So in the meantime, SPS is financing that PTC to the customer, because they haven't yet monetized the credit, either through, in your hypothetical, they haven't yet monetized it through the 3 options I mentioned, whether it's currently using it, carrying it forward, or selling it. So again, SPS is financing that cost. by sharing. I mean, they're sharing the PTC, right? And that's great, except they have to finance it because they haven't yet gotten the cash benefit from the IRS or from a buyer.
Yeah, and so if what I just learned is the transfer of a PTC has to occur by September or October or something of the year after it was earned.
Correct.
And so if you got into a situation where for some reason it couldn't be sold in the market, or the market was saturated to a point that instead of earning 90 cents on a dollar, they started to sell at 50 cents on a dollar, the equation of the value of selling that would change. The incentives for transferring it might change. And there could be a situation where if it doesn't get transferred or it becomes impossible to transfer it, then it has to be held until it can be applied to a tax liability. Is that a fair understanding of what I just learned?
Technically, yes, except that hypothetical is pretty extreme. I mean, I just don't imagine. I can't imagine that happening. I mean, technically yes, but again, that's really extreme.
And if it's so extreme, then there wouldn't be much risk to SPS to put a time limit on how long SPS would be allowed to hold that deferred tax asset, because it'd just be a useless provision in the stipulation of, like, can't hold, the ratepayers will not pay carrying costs past 3 years. And the situation is so extreme that there wouldn't be incentive to avoid that provision in a stipulation, would there?
I don't know. We evaluate the transfer costs, and we've been consistent. It's tough because I can't share the exact amount. We've been consistently getting good transfer discounts. So, and we can exhibit that in a closed session. If it were to ever change radically, again, I think we'd be reevaluating the approach. I can't accept the hypothetical. It is so extreme. I will note, and this doesn't, for technical clarification from a question you had yesterday, production tax credits, ITCs, they can be carried forward into a future year's tax return for 20 years or back one. So, and SPS has exhausted its carryback ability, but they do have the carry forward ability, but it is limited to the 20 years for 20 years future tax returns.
Ms. Koch, let me just interrupt here to alert everybody that we're just about at the end of our time allotted for our hearing today. It's 4:58. I just wanted to, I believe Hearing Examiner Gecko may have some remaining questions for you tomorrow morning. But exactly, Ms. Lynch, I wanted to check with the parties as we traditionally do at the end of the day and make sure that there isn't anything we need to discuss. Go ahead, Ms. Lynch.
Thank you so much. I had a question about Commissioner O'Connell's question about jurisdiction and allocation and fairness to parties. I think some of the witnesses have been asked the question, some of the witnesses have not. And I'm I don't understand why some have been asked the question, some have not. And I think maybe it would level the playing field if all parties incorporated that response into a post-hearing brief, like they were directed to, or something along those lines. And then,
I think that's,
okay.
Go ahead, Ms. Lynch.
Go ahead. That's all right.
I was just going to say on your first point, I think that's well taken. I think the idea is for the parties, not necessarily each witness, but for at least one witness for the party to, maybe it's a competent, the witness that's most competent to answer that. That's fine. But I think that your idea is well taken. We'll consider it. Again, this is something that the chairman is quite interested in, so it most likely will feature in a post-hearing briefing order.
Okay, thank you. And I'll
Sure.
reserve the other if needed.
Okay, you don't have a follow-up question then? Okay, all right, thanks. No worries. It's getting late. It's been a long 2 days. Mr. Rushoff, please share your thought.
Yeah, good afternoon. I had a question regarding the witness order. One of our witnesses, Miss Hashlamun, had a conflict, I believe after 2 tomorrow afternoon, and also a conflict on Thursday. I had conferred with OPL counsel, Mr. McMillan, about potentially having the NMLCG witnesses jump Occidental in line so we could go before them to kind of clear up that conflict and also allow all of our witnesses to go in one block, if that's okay with the hearing examiners.
That may be appropriate. Let us get back to you in the morning with that. And just to
Okay.
confirm, Mr. Rushoff, you said Ms. Hashlamun is unavailable after 2 p.m. tomorrow.
Correct.
Okay, and that's the only unavailability that you have to share with us?
Correct.
Okay. All right. Thank you, Mr. Rushoff. I'll discuss that with hearing examiner Getko, and we'll try to do our best, as we always do, to accommodate our parties and witnesses. Yes,
Okay,
Mr.
thank you.
McMillan.
And
Sure.
Your Honor, Michael McMillan for OPL. I don't object to having an MLCG jump us in the order. I did want to ask if anyone, especially Your Honors, had questions for Ms. LeConte for OPL. I realized today that I left her off of the availability chart, and she is going to be on vacation on Thursday and Friday.
Okay, so she'll be out, and I'll discuss that also with hearing examiner Getko here in a few minutes, momentarily, and we'll let you know if that will be an issue. But for the time being, I will note her unavailability for day 4 and day 5.
Thank you, Your Honor. I did notice that no one designated her for cross, if that's helpful.
Right. Yes, it is helpful. Thank you, Mr. McMillan. Okay. Any other matters, issues, concerns before I wrap up and just give some final thoughts? Okay. Well, it's 5:02. Thank you, everybody, once again. Thank you to all the witnesses who have been very patient and diligent in their presentation. Unless there's anything else, I want to thank Mr. Lee as well, and we'll reconvene here tomorrow at 9 o'clock. I'll be on again, probably around 8:45, 8:50, and we can take any last minute or final procedural matters off the record before we go online, as we've been doing. So thank you again, everybody. Have a good night and be safe, and we'll see you in a few hours. Thank you, everybody.